and Barbara Goy for the prosecution. We're joined by our case manager, Janet Stewart, and today we'll be joined in the courtroom by three of our colleagues right now. That is Rafael Braga da Silva, and later in the day, Maria Yakusheva and Catherine Marsden. Thank you.
Appearances for the defense?
Good morning, Madam Presiding Judge and Your Honors. Appearing for the defense, Dragan Ivetic, co-counsel for Mr. Mladic, and I'm joined in court by Peter Louise Bagot, legal consultant for Mr. Mladic. Thank you.
Thank you. As a preliminary matter before calling on Mr. Mladic's counsel, I note that defense have requested through a letter to the Appeals Chamber Senior Legal Officer that their assigned legal consultants, Ms. Peter Louise Bagot and Mr. Boris Zoko, respectively be granted the right of audience during the appeal hearing. These requests have been unopposed. I further note that in submitting this request, counsel for Mr. Mladic provided letters from the Office of Legal Aid and Defense Matters of the mechanism demonstrating that Ms. Bagot and Mr. Zoko have been officially assigned as legal assistants to Mr. Mladic's legal team. In these circumstances, the Appeals Chamber grants Ms. Bagot and Mr. Zoko a right of audience at the present hearing. Now, counsel for Mr. Mladic, sorry I called you before. Thank you.
Thank you.
Mr. Mladic and yes, Mr. Mladic and the prosecution have both appealed against the judgment rendered on 22 November 2017 by the Trial Chamber 1 of the International Criminal Tribunal for the former Yugoslavia. On 16 December 2019, the Appeals Chamber scheduled the appeal hearing to take place on 17 and 18 March 2020. This hearing was stayed on 6 March 2020 on the basis of Mr. Mladic's request regarding his then upcoming surgery and recovery. On 1st May 2020, the Appeals Chamber noted Mr. Mladic's progress in recovering from surgery and scheduled the appeal hearing to take place on 16 and 17th June, subject to change in light of coronavirus pandemic-related restrictions. On 28 May 2020, the Appeals Chamber further stayed the scheduled appeal hearing given the unavailability of counsel and complications arising from the coronavirus pandemic-related restrictions. On 17th June 2020, the Appeal Chamber scheduled the present hearing. This case concerns the criminal responsibility of Mr. Mladic, who was appointed commander of the main staff of the This is nonsense. Theo? Right, we are reconnected. As I was saying, this case concerns the criminal responsibility of Mr. Mladic, who was appointed commander of the main staff of the Army of Republika Srpska, the VRS, on 12 May 1992 by the Bosnian Serb Assembly. Mr. Mladic remained in command of the VRS main staff until at least 8 November 1996. The trial chamber convicted Mr. Mladic pursuant to Article 7.1 of the ICTY Statute of genocide, crimes against humanity, violations of the laws or customs of war. In particular, the trial chamber concluded that from 12 May 1992 until 3 November 1995, Mr. Mladic participated in the overarching JCE, a joint criminal enterprise with the objective of permanently removing Bosnian Muslims and Bosnian Croats from Bosnian Serb claimed territory in Bosnia and Herzegovina through persecution, extermination, murder, inhumane acts, forcible transfer, and deportation. The trial chamber convicted him of these crimes. The trial chamber found that between 12 May 1992 and November 1995, Mr. Mladic participated in a joint criminal enterprise with the objective of spreading terror among the civilian population of Sarajevo through a campaign of sniping and shelling. The trial chamber convicted him of the crimes of terror, unlawful attacks on civilians, and murder. The trial chamber also found that from the days immediately preceding 11 July 1995 to at least October 1995, Mr. Mladic participated in a joint criminal enterprise with the objective of eliminating the Bosnian Muslims in Srebrenica by killing the men and boys and forcibly removing the women, young children, and some elderly men. It convicted him of the crimes of genocide, as well as persecution, inhumane acts, forcible transfer, murder, and extermination. Finally, the trial chamber found that from approximately 25 May 1995 to approximately 24 June 1995, Mr. Mladic participated in a joint criminal enterprise with the objective to capture United Nations personnel deployed in Bosnia and Herzegovina and detain them in strategic military locations to prevent the North Atlantic Treaty Organization from launching further military airstrikes on Bosnian Serb military targets. It convicted him of the crime of hostage-taking as a violation of the laws or customs of war. The trial chamber sentenced Mr. Mladic to life imprisonment. Mr. Mladic advances 9 grounds of appeal, with numerous sub-grounds challenging his conviction and sentence. He requests that the appeal chamber reverse erroneous findings of the trial chamber, quash his convictions, and acquit him. In the alternative, Mr. Mladic seeks a retrial or a reduction of his sentence. The prosecution responds that Mr. Mladic's appeal should be dismissed in its entirety. The prosecution presents 2 grounds of appeal, challenging certain findings or conclusions of the trial chamber, including its acquittal of genocide in relation to the overarching JCE. The prosecution requests that the appeal chamber correct the trial chamber's errors and convict Mr. Mladic of genocide under the count 1 of the indictment, pursuant to the first category of joint criminal enterprise, or alternatively, the third category of joint enterprise, or as a superior under Article 7.3 of the ICTY statute. Mr. Mladic responds that the prosecution's appeal should be dismissed in its entirety. I now summarize the manner in which we will proceed. I would like to remind both parties that the appeal process is not a retrial de novo, and the parties must refrain from repeating their case as presented at trial. The arguments must be limited to alleged errors of law which invalidate the trial judgment, or alleged errors of fact which occasion a miscarriage of justice. Throughout the hearing, the parties may present the grounds of appeal in any order they consider suitable. The parties shall present their submissions in a precise, clear, and concise manner, and should also provide precise references to materials supporting their oral arguments. It's okay. Right. I would also like to remind both parties to particularly careful not to reveal any confidential information, including information that could identify protected witnesses. As set out in the 17th July 2020 decision, the hearing schedule has been adjusted to ensure the safety of all those participating in person, and we will adjust it further to ensure that all breaks are 1 hour long to allow for thorough cleaning and ventilation. Hearing today and tomorrow will proceed as follows. Today we shall first hear the submissions in support of Mr. Mladic's appeal for 1 hour. After a pause of 1 hour, we shall continue to hear the submissions in support of Mr. Mladic's appeal for 1 hour. Then, after a pause of 1 hour, counsel for Mr. Mladic will have another hour to make submissions. After a 1 hour break, the prosecution will respond for 1 hour. Following a pause of 1 hour, the prosecution will continue its response to another hour. Tomorrow, starting at 9:30 a.m., the prosecution will have 1 hour to finish its response. After a pause of 1 hour, counsel for Mr. Mladic will have 1 hour to reply to the prosecution's response. This will be followed by a pause of 1 hour, after which we will hear the final 30 minutes of reply submissions in support of Mr. Mladic's appeal. Directly following this, we shall hear the prosecution's appeal submissions for 30 minutes. After a pause of 1 hour, counsel for Mr. Mladic will respond to 30 minutes for 30 minutes. Subsequently, the prosecution will have 15 minutes to reply. Finally, Mr. Mladic will have 10 minutes for an optional personal address. Now, I would like to invite counsel for Mr. Mladic to present his appeal. You have 1 hour for this part of the submission.
Good morning and thank you, Madam Presiding Judge. Before I begin, I must place on the record that during the submissions that you just made in the courtroom, we had about several minutes of loud English being broadcast, and Mr. Mladic complained that he had difficulty following the proceedings due to the same, but that has now been resolved. Your Honors, before we begin with the appeal, I am mandated to put on the record pertinent information, objections, and reservations of rights to protect Mr. Mladic's interests and explain my presence. Lead counsel Lukic and legal consultant Zorko from Serbia are unable to attend based on consultation of their ethical code and bar, which prevents them from acting against the explicit instructions of their client. An absent waiver prevents them from substituting their own interests over the rights of the client. Likewise, the risk of travel, bringing illness to the client. Lastly, the Serbian Code and Bar have a very strong stance forbidding purely video link proceedings in this matter. These statements, and my own, are made from a difficult position, imposed by the majority decisions on our most recent filings to press on with these proceedings without a legal competency hearing as to Mr. Mladic. Upon consultation and discussion with the Ethics Board lawyers of the Illinois Supreme Court Attorney Registration and Disciplinary Commission, and upon diligent review and study of the relevant rules of conduct they referred me to, as well as pertinent substantive legal literature and jurisprudence relating to the same, I have been reminded of my ethical and professional duties that are partly in conflict with the majority decision to proceed with the appeals hearing today. In light of a bona fide, reasonable conclusion as to my client's ill health and inability to meaningfully prepare and take instructions from him, and a reasonable belief in his diminished capacity, I am personally and professionally required to make a strong record objecting to the majority decision and this appeals hearing today. Under my domestic, ethical, and professional obligations and case law, this hearing today is inappropriate and threatens, as Presiding Judge Nyambe stated in her dissent, a miscarriage of justice, such that I cannot abide to be a silent participant in this questionable proceeding. My presentations during the last status conference and the defense's subsequent written filings on the record have all been undertaken in accord with the Model Rules of Ethics, comments 1.14, etc., and also Illinois Rules of Professional Conduct 1.14, etc., dealing with diminished capacity clients. Lengthy consultations with my ethics board and diligent review of the prevailing authorities on this matter mandate my further action as follows. Aware of my role as an officer of the court and concerned about not misleading the court, counsel, such as I, must seriously question the propriety of allowing my impaired client and myself to proceed today when competency issues remain unresolved. Here, I would direct you to Bennett, a guided tour through selected American Bar Association standards relating to incompetence to stand trial. 53, George Washington Law Review 375 at pages 383 to 384, 1985. The American Bar Association Criminal Justice Mental Health Standards, particularly 7-4.2, requires me as defense counsel to raise competency even if that may conflict with obligations to the court. To do otherwise, I would violate my jurisdiction's ethical professional standards, and I would betray my client's interests. Further, I note that both the prosecutor and judges have that same ethical and professional obligation to prevent the legal process from being demeaned by proceeding against an incompetent defendant. Her Honor, Presiding Judge Nyambe, and the defense have acted in accord with the professional obligations placed on us as officers of the court. The client, Mr. Mladic, has ultimate authority to determine the purposes served by his counsel, especially on appeal, where significant decisions are made. I am unable to meaningfully gain instruction from Mr. Mladic, nor be assured that he is able to meaningfully participate and follow same owing to the majority decision. Under these circumstances, the authorities consulted in my home jurisdiction dictate that I, the attorney, should protect the due process rights of the alleged incapacitated individual and advocate strenuously for my client's wishes. If I, the attorney, do not do so, the alleged incapacitated person has no voice in these proceedings. This is an ethical obligation of I, the attorney, as an officer of the court, which also protects these proceedings from attack based on due process violations, here contained in the statute of the IRMCT and the jurisprudence. Thus, I must make this objection and make a record of the majority's error and its consequences. It is a denial of due process to sentence or proceed criminally against someone who is incompetent to stand trial. And at that point, the court should, on its own initiative, conduct a hearing on that matter. I will cite 3 United States Supreme Court cases. Pate v. Robinson, 1966. Dusky versus United States, 362 U.S. 402, 1960, per curiam, cited with approval in Indiana versus Edwards, also the Supreme Court, 2008. Second, there is a presumption that psychiatric and other medical examinations will be included in the decision-making process. Mata versus Johnson, United States Court of Appeals, 5th Circuit, 2000, citing the U.S. Supreme Court in Reyes v. Payton, 384, U.S. 312, 1966. Even assuming arguendo that a court has not received evidence raising a bona fide doubt as to competency, my Supreme Court mandates that courts indulge every reasonable presumption against waiver of fundamental due process rights. Mata versus Johnson, again from the U.S. Court of Appeals, 5th Circuit, 2000, citing to the U.S. Supreme Court in HAGUE versus Easton, 106 U.S. 408 at page 412. In the instant case, Mr. Mladic, the majority, without medical expert examination on this matter, have forced me to this untenable position of proceeding with the appeal hearing in violation of all the aforesaid legal tenets from my domestic jurisdiction. And in some cases, in violation of domestic and professional ethics standards in other jurisdictions, which is why Counsel Lukic and Consultant Zorko cannot attend today, as to do so would place them in violation of their domestic ethics code and licensing body. Therefore, my presence here today as co-counsel is under a continued objection, protest, and strongest possible reservation of rights. My client has not waived any of his rights, nor have I or Counsel Lukic, as his counsel, waived his rights in his stead. We cannot as to do so would infringe upon his due process rights. Your Honors, my presence here today is of a limited scope, and again is due to the majority decision. I am professionally unable to fully present the appeal as envisaged, nor obtain meaningful participation, nor instruction from my client due to the position of the majority having placed on me. I, in accordance with my ethical duties, and after consultations with my home ethics bar and review of relevant and authoritative jurisprudence and literature, do not consent to this being the ultimate appeals hearing, and will undertake to preserve all my client's rights to a repeated proceeding if and when he has undergone a capacity review that finds him competent to do so. I note, in light of the strongly worded dissent of Presiding Judge Nyambe, that proceeding in this way may be regarded as a miscarriage of justice, threatening the integrity of these proceedings without any medical expert testimony as to the current mental fitness and capacity and ability to meaningfully participate of Mr. Mladic. Based on the same, Mr. Mladic does not waive his right to have a full appeal hearing on another date. I do not waive rights to any part of the appeal, and I engage today in a limited capacity in good faith as an officer of the court, and in accordance with my consultations with the Domestic Ethics and Licensing Bar of Illinois and the Federal Court of the United States. Subject to this objection and reservation of rights, I now defer to my colleague to make a record of the substance of the appeal to the extent that she and I are able to do so today under these circumstances. And I thank you very much, and I pass the floor to Ms. Bagot.
Good morning, Madam Presiding Judge, Your Honours. Mr. Ivatic and I will be making submissions on behalf of Mr. Mladic on the grounds of appeal set out in the appeal brief. We invite the Chamber to overturn Mr. Mladic's convictions entered by the trial chamber on the 22nd of November 2017. We do not intend to make submissions on every ground and every sub-ground in the appeal brief. Given the size of the appeal and the detailed and comprehensive written submissions the Chamber has already received in the form of the appeal brief and the reply to the prosecution's response, we are addressing the Chamber on selected grounds. I will be addressing the Chamber on grounds 1, 2 and 4 of the appeal brief. Mr. Ivatic will be addressing the Chamber on grounds 3 and 5 and making our concluding remarks. Before turning to the substance of this appeal, we wish to make a few introductory remarks. International criminal courts and tribunals are unusual institutions. Decisions made by the tribunal has an impact that extends beyond purely legal outcomes. The consequences of a conviction, or dare I say it, an acquittal, has an impact that extends beyond these four walls. For many, convictions are seen as a victory and acquittals a failure. Not only did the prosecution come under scrutiny when convictions are not secured, but criticism is directed towards the judiciary. It is the fact that the application of the black letter of the law can in some way be interpreted as betraying the interests of justice that makes international criminal courts and tribunals so unusual as legal institutions. They are they not, just criminal courts hearing criminal trials at the end of the day. It is trite to say, but an important reminder, that trials before this tribunal require the same strict application of the burden and standard of proof as any other criminal trial. They require the same unflinching application of the presumption of innocence at every stage of the process. If the prosecution fails to discharge its burden of proof, then the accused must be acquitted. The law is dispassionate in this sense. As Justice Jackson made it clear in his opening statement at the Nuremberg trial, quote, "We must never forget that the record on which we judge these defendants today is the record on which history will judge us tomorrow." We must summon such detachment and intellectual integrity to our task that this trial will commend itself to posterity as fulfilling humanity's aspirations to do justice. End quote. When international criminal trials were in their infancy, there was a clear recognition and understanding that the application of the law should be rooted in fairness. Both in the past and the present, it is understood that justice cannot be served if corners are cut and due process norms are cast to one side. When judges at this tribunal are sworn in, they take an oath to honourably, faithfully, impartially and conscientiously perform their duties and exercise their powers. Of this appeal, Mr. Ivetic and I will address the trial chamber's errors. Some, as this chamber will have
Ms.
seen...
Beckett, we have lost the presiding judge. Could you kindly wait till we reconnect?
Of course. Do we know at which point?
We are back. You can hear me? You can hear me now?
Yes, Judge, we can hear you now. We are reconnected. Thank you.
Sorry, Miss Bagot, they said my connection dropped. You may continue.
Madam Presiding Judge, please could you let me know where we were at before the connection broke?
You were at the point where you were reminding us about the fact that the decisions of this tribunal will transcend to many borders, or something to that effect. I don't have a copy of the transcript, so I think we start from where you're saying which counts you are going to deal with.
I'll go back.
Yes.
So I will be addressing the Chamber on grounds 1, 2 and 4 of the appeal brief. Mr Ivetic will be addressing the Chamber on grounds 3 and 5 and making our concluding remarks. Before I turn to the substance of this appeal, we wish to make some introductory remarks. International criminal courts and tribunals are unusual institutions. Decisions made by their tribunal have an impact that extends beyond purely legal outcomes. The consequences of a conviction, or dare I say it, an acquittal, has an impact that extends beyond these four walls. For many, convictions are seen as a victory and acquittals a failure. Not only do the prosecution come under scrutiny when convictions are not secured, but criticism is directed towards the judiciary. It is the fact that applying the black letter of the law can in some way be seen to be betraying the interests of justice that makes international criminal courts and tribunals so unusual as legal institutions. They are they not, just criminal courts hearing criminal trials at the end of the day. It is trite to say, but an important reminder, that trials before this tribunal require the same strict application of the burden and standard of proof as any other criminal trial. They require the same unflinching application of the presumption of innocence at every stage of the process. If the prosecution fails to discharge its burden, then the accused must be acquitted. The law is dispassionate in that sense. As Justice Jackson made it clear in his opening statement at the Nuremberg trial, we must never forget that the record on which we judge these defendants today is the record on which history will judge us tomorrow. We must summon such detachment and intellectual integrity to our task that this trial will commend itself to posterity as fulfilling humanity's aspirations to do justice. When international criminal trials were in their infancy, there was a clear recognition and understanding that the application of the law should be rooted in fairness. Both in the past and the present, it is understood that justice cannot be served if corners are cut and due process norms are cast to one side. When judges at this tribunal are sworn in, they take an oath to honourably, faithfully, impartially and conscientiously perform their duties and exercise their powers. Incumbent upon the judiciary is a heavy burden to make often difficult and unpopular decisions to give effect to what is right as a matter of law. What we invite the Chamber to do may not be easy or popular, but in our submission, it is right. It is right because it will represent the dispassionate application of the law. It is right because it will represent that this Chamber recognises that the fundamental principle of a right to a fair trial is more than just empty rhetoric. During the course of the appeal, Mr Ivetic and I will address the trial chamber's errors. Some, as this Chamber will have seen from the appeal brief, are also substantive legal errors that for many years successive appeals chambers have shied away from grappling with. The errors identified in the appeal brief, the appellant submits, infect all the convictions, such that those entered by the trial chamber on counts 2 to 11 of the indictment should be reversed and not guilty verdicts entered. Ground 1. The appellant submits that the trial chamber erred by holding Mr Mladic criminally responsible for what the appellant has termed unnamed, unscheduled incidents. The appellant's written submissions are at paragraphs 41 to 60 of the appeal brief and paragraphs 8 to 14 of the reply. To assist the Chamber, my submissions will focus on: first, how the appellant defines unnamed, unscheduled incidents; second, the issue of notice; third, the fact that the error was not remedied through the presentation of a general defence or cross-examination; and finally, the impact of the trial chamber's error. Definition. Scheduled incidents are incidents that are identified in a schedule attached to the indictment. They are numbered, named, and listed in black and white. Notice is given that they form part of the allegations against the accused by the very fact that they are annexed to the indictment. Unscheduled incidents are incidents that can be relied on by the prosecution to prove material elements of the crime, for example, a course of conduct. Notice of these is given in, for example, the 65-ter witness list, in which the prosecution explicitly states that a witness will be called to give evidence on an, quote, unscheduled incident, close quote. Examples of this include RM 109, page 222 of the 65-ter witness list, at paragraph 3, quote, the witness can also testify to his personal participation in the investigation of unscheduled incidents of sniping and shelling, close quote. RM 138, page 219 at paragraph 6, quote, the state hospital was targeted with shell and mortar fire, brackets, unscheduled, close brackets, close quote. Here, the fact that the witness would give evidence on what the prosecution considered to be an unscheduled incident was explicitly identified as such. Unnamed, unscheduled incidents are something quite distinct. They are incidents that do not fall in either of the aforementioned categories. What they are, in fact, are incidents that witnesses made accusations about at trial in the course of their evidence on scheduled incidents or other defined subjects, but which no notice was provided to the defence that they were in fact incidents, either scheduled or unscheduled, for which Mr. Mladic could be held responsible. To highlight this distinction, it's useful to go back to basics with an example. An accused stands trial for incident 1. Witness A is called to give evidence about incident 1. In the course of this, they make additional accusations against the accused. These are not charged. In an adversarial trial, a trier of fact could not enter convictions on these other accusations. The prosecution would have to put the defence on notice that it sought to add them to the indictment before any convictions could be entered. This general principle remains unchanged in an international criminal trial. Before convictions can be entered, notice must be given. Mere accusations fall outside the scope of the indictment. Contrary to the prosecution's submissions at paragraph 6 to 13 of its response, this issue is not about the indictment being defective. The issue is that an indictment cannot be expanded to include any accusations made during the course of a trial. This, we say, is the trial chamber's error. It convicted Mr. Mladic of such accusations that were never identified as scheduled or unscheduled incidents. Notice. As set out previously, when the prosecution sought to call a witness to give evidence about an unscheduled incident, it specified this, and in doing so gave notice to the defence that Mr. Mladic could be held criminally responsible for these incidents. It follows, therefore, that the appellant withdraws incidents for which the defence received notice of in this manner from the Chamber's consideration. In contrast to the approach taken to unscheduled incidents, the defence did not receive notice of unnamed, unscheduled incidents. The first time that the defence was made aware that these accusations were being treated as unscheduled incidents was when the judgment was rendered. It was the trial chamber that referred and identified them as unscheduled incidents, not the prosecution. By way of example from the appellant's brief at paragraph 48, incidents Srebrenica Incident U, opportunistic killings, 13th to the 14th of July, 1995. Sniping Incident E, 31st of March, 1993. Srebrenica Incident W, 23rd of July, 1995. Srebrenica Incident, Sniping Incident K, 9th of November, 1993. Shelling Incident D, 14th of May, 1992. Cruel and Inhumane Treatment Incident J, II, 31st of May, 8th of June, 1992. Unlawful Detention Incident E, III. For each of these, the 65-ter list did not make any reference to these accusations as unscheduled incidents in the summary. In fact, the accusations simply form part of the narrative on the scheduled incident or defined subject matter the witness was called to give evidence about in the pre-trial brief, witness summaries, or 65-ter list. In the absence of notice that these accusations were being treated by the prosecution as unscheduled incidents, the trial chamber erred by treating them as such. Contrary to the prosecution's suggestion at paragraph 12, the use of inclusive language in the indictment is not a blank check to convict Mr. Mladic of any accusation made before the trial chamber. There must be limits as a matter of fairness. The appellant submits that it is contrary to the most basic principles of an adversarial criminal trial if any accusations made could fall within the scope of the indictment without notice. The prosecution must identify what case and which incidents it seeks convictions of, so the defence can defend against each incident specifically accordingly. The presentation of a general defence or cross-examination did not cure this error. Absent notice and specifying the crimes alleged, the only defence available is a general one. And a general
Yes, Ms. Bagot, would this be a nice time to take a break for 1 hour?
Yes, this is a convenient moment.
Very well. The proceedings will pause for 1 hour and we'll proceed. What's the time now?
It is 11:30, 10.
So we resume at 12:30?
Madam
Right.
Presiding Judge, it will be 11:30.
Sorry, my time is 11:30 about. It's the same time as The Hague. No?
No, it's 10:30 now. In fact, it's 10:31 now. We should be resuming at 11:31.
Oh. So it's 10:30 there. Here. No, my phone is here. Yeah, okay, 11:30 my time, we resume.
All right.
Time.
We will be.
Thank you.
No, no new message.
All right, we will.
Very well. You don't have to repeat appearances as before.
Please be seated.
When we broke off, the defense were making their submissions, and as at the time when we broke off, according to my record, you have 2.5 hours remaining of your allotted time. This session will last 1 hour until 12:30. You may proceed.
Thank you, Your Honor. Just before we begin, to put on the record that for the first 25 minutes of the break, I was unable to have telephonic communications with my client due to technical issues. That has now been resolved. Thank you.
Sorry, can you repeat that again,
Mr. Ivitic, during the first 25 minutes of the break, the telephonic line, privilege line, did not function, and I was unable to speak with my client. That has now been resolved. So for half the break, I did not have an opportunity to speak to Mr. Mladic.
I think we should allocate this time to the defense at the beginning of this session, which means their time will be 1 hour 25 minutes for this session. We may proceed. Mr. Lukic?
Mr. Ivitic, Madam President, can you please clarify?
Sorry?
Can you please clarify? We're not sure as to what the last portion of what you said indicated.
Okay, the audio is not very clear. My understanding is that you said you lost 25 minutes because of miscommunications and breakdowns in communications. Is that correct?
No, Madam President. During the recess of the proceedings, I was unable to have privileged communications with my client due to technical difficulties, and therefore did not have access to my client for approximately 25 to 27 minutes of the allocated 1 hour break.
Okay, so you lost 25 minutes of the time you should have spent with your client during break due to miscommunications?
That's correct, Your Honors.
You want to consult with your client now before we proceed?
In addition, meaningful instructions can be taken in this regard. Absent notice, neither can cure the trial chamber's error. The prejudice suffered by Mr. Mladic lies in the fact that these accusations were transformed into unscheduled incidents by the trial chamber at the judgment stage. Therefore, it was too late for the defence to defend against them in the same way that it would with scheduled and unscheduled incidents that it was put on notice of. The impact of this error. As a result of the trial chamber's error, Mr. Mladic was held criminally responsible for these unnamed unscheduled incidents, which constituted crimes against humanity, terror, unlawful acts and persecution. The trial chamber then took these into account when determining the ambits of the count on the indictment and the extent of his criminal responsibility. For the reasons set out, the appellant invites this chamber to reverse the findings on the crimes identified in paragraphs 52 to 58 of the appeal brief. Turning now to ground 2. The appellant submits, first, that there are compelling reasons for this chamber to revisit Camara to determine whether the trial chamber erred by taking judicial notice of facts relating to Mr. Mladic's proximate subordinates under Rule 94B, and second, that the trial chamber erred by applying a heightened standard to rebuttal evidence. These will be taken in turn. The appellant's submissions on Camara are at paragraphs 62 to 95 of the appeal brief and paragraphs 16 to 19 of the reply. The ICTR Appeals Chamber held in the Camara interlocutory decision that facts relating to the conduct of the physical perpetrators of crimes for which an accused is alleged to be criminally responsible may be subject to judicial notice, paragraph 50. The appellant submits that the relevance of the Appeals Chamber's findings in the Garlich Rule 92 bis C decision and the Milosevic interlocutory decision lies in the further guidance they issued about the circumstances in which trial chambers should withhold their discretion in this specific context. The Garlich Rule 92 bis C decision considered that admitting Rule 92 bis evidence that went to the conduct of the, quote, immediately proximate subordinates, close quote, of an accused was inherently unfair when they were charged under Article 7.3 or the evidence goes to the elements of Article 7.1. It decided this on the basis of what it considered to be the, quote, short step, close quote, from a finding that crimes charged were committed by such subordinates to a finding that the accused knew or had reason to know that these crimes were about to be or had been committed. Paragraph 14. The Appeals Chamber said that careful consideration should always be given by trial chambers to the exercise of its discretion in these, quote, special and sensitive, close quote, situations. Paragraph 19. The Garlich Appeals Chamber did not define immediately proximate subordinates with reference to the rank of an accused, but rather whether the conduct of them was so widespread that the inference would be drawn that, quote, there is no way that the accused could not have known about it, or the accused had to be aware, close quote, of the objectives of his subordinates. Paragraph 14. It considered that where this link became sufficiently pivotal to the prosecution's case on responsibility, quote, it may not be fair to the accused, close quote, to permit this evidence in written form as it could not be challenged by the defence. Paragraph 15. In the same vein, but specifically in the context of adjudicated facts, the Appeals Chamber in the Milosevic decision held that, quote, while it is possible to take judicial notice of adjudicated facts regarding the existence of crimes, the actus reus and mens rea element supporting the responsibility of the accused for the crimes in question must be proved by other means than judicial notice, close quote, paragraph 16. It distinguished this from adjudicated facts that provided evidence as to the existence of crimes committed by others for which the accused was not charged with. Paragraph 16. Therefore, both appeals chambers considered that if the link between the accused and the crime committed was such that the responsibility of an accused could be easily inferred from the untested witness statement or adjudicated fact, then the prosecution would have to establish this by calling evidence that could be confronted by the defence. This, the appellant says, is the conceptual issue that was overlooked by the Camara Appeals Chamber and why the Mladic Trial Chamber's reliance on it led it into discernible error. An example. The judgment highlights that the trial chamber took judicial notice of facts that related to the criminal activities conducted by those the prosecution alleged were Mr. Mladic's subordinates to hold him responsible for them.
Bagot, could you kindly pause? We have dropped the signal to the presiding judge. Thank you.
The counsel is also asked to slow down for purposes of interpretation. She is going quite fast. Thank you. Jeez.
Madam Presiding Judge, are you in a position to hear and see us now?
Sorry?
We have re-established connection, it appears.
Okay, you may proceed.
Madam Presiding Judge, it might assist if you could let me know what the last thing you heard was before I cut out.
You had started talking about you were into County 2.
How far into Count 2?
Yes. You may proceed where you left.
Madam Presiding Judge, I'm just conscious of the fact that other judges and particularly other people in the courtroom would have heard my submissions, and I'm conscious of the fact that if you cut out, perhaps you've missed a portion of it. And if it would assist you, I can go back.
Regrettably, I'm unable to help because I can hardly hear you or any other judge. We are thinking we are going to rely on the transcript when it is eventually generated, because excuse me, unlike normal proceedings, I should have a transcript on the screen to follow the proceedings. I don't have that possibility.
I will take it from where I left off, and then the transcript will reflect the words I spoke in the interim period.
Okay.
By way of example, I would refer the Chamber to incident of the 23rd of July, 19... on this day. An air bomb was fired from a northwesterly direction from SRK held territory. Close quote. Paragraph 2210, footnote 9385, an adjudicated fact 2871. On the basis of a judicial fact alone, no prosecution evidence, it concluded that, quote, a member or members of the SRK launched a modified air bomb, close quote, on that day and killed 2 civilians, seriously injuring others. Paragraph 2212. Pausing there. The prosecution's case was that Mr. Mladic was the most senior officer in the VRS and that he significantly contributed to achieving the objectives of the JCEs primarily through the use of the VRS forces. Indictment, paragraph 13. These specifically included the SRK, which the prosecution said, quote, implemented, quote, quote, Mr. Mladic's orders through ethnically cleansing municipalities and terrorizing Sarajevo's civilians through a campaign of shelling and sniping. Prosecution final trial brief, paragraphs 102 to 103. In light of this, the adjudicated fact established that the crimes charged were committed by Mr. Mladic's alleged subordinates. Given that the prosecution's case was that the SRK were implementing Mr. Mladic's orders and were used as tools to achieve the objectives of the JCEs, the adjudicated fact on the identity of the perpetrator went to the core of its case on his responsibility. Despite this, the trial chamber took judicial notice of this fact in the absence of any prosecution evidence that could establish the SRK's responsibility for the incident. The appellant submits this example demonstrates the error with the trial chamber's reliance on the Camara approach. The trial chamber considered that there were no limitations on which judicial facts could be taken, judicial notice could be taken of, in the context of the conduct of other members of the JCE or the physical perpetrators. This is just one example of when the trial chamber took this approach in relation to Mr. Mladic's alleged proximate subordinates. The appellant invites the chamber to consider the others identified, for example, at paragraphs 107 and 108 of the appeal brief. It is important to consider how other trial chambers have exercised their discretion to highlight the divergence in practice. I would refer the Chamber to paragraph 69 and footnotes 97 and 98 of the appeal brief in this regard. There are broadly two approaches that can be seen in the jurisprudence: the Camara approach and the Milosevic approach. An example of the latter is an approach taken by the trial chamber in the Stanisic and Juplagin case. The judges held that, quote, where the proposed fact goes to the core of the prosecution's case and relates to the conduct of others for whose criminal acts and admissions the accused is alleged to be responsible, the trial chamber will nevertheless exercise its discretion to withhold judicial notice if it considers that doing so would be in the interests of justice. Paragraph 41. In light of the prosecution's case against Miko Stanisic and Stojan Juplagin, namely that in their roles as the Minister of the RSMUP and Chief Regional Security Services Centre of Banja Luka respectively, that they committed crimes through the police, the trial chamber concluded that, quote, where a proposed fact refers to the criminal activities conducted by the police within an ARC municipality, the fact is considered to go to the core of the case. Close quote. Paragraph 41. For that reason, it withheld judicial notice of such facts in the interests of justice. Importantly, the trial chamber in this case did not limit which members of the police this would apply to by, for example, rank. Given the prosecution's case, it considered that all members of the police could constitute the accused's, quote, immediately proximate subordinates, close quote. This demonstrates that, contrary to the prosecution's assertion at paragraph 30, this is not limited to those close to an accused in rank. Had the Mladic trial chamber taken this approach, it would have withheld its discretion and declined to take judicial notice of facts that related to the criminal activities conducted by those the prosecution alleged were Mr. Mladic's subordinates in the interests of fairness. The appellant submits that the fact that there is such a divergence in the approach taken in the jurisprudence gives further impetus to revisit the appeals chamber's decision in Camara and articulate the correct legal standard. By way of conclusion, the appellant emphasises that it is not argued that the trial chamber can never take judicial notice of facts. The appellant asserts that the trial chamber fell into error when it admitted a specific category of facts, namely those that related to the criminal activities conducted by those the prosecution alleged were Mr. Mladic's subordinates acting under his orders. As, the appellant says, these were sufficiently pivotal to the prosecution's case on his responsibility for the alleged conduct. Therefore, it should have presented evidence itself in this regard. The appellant invites this chamber to find that the trial chamber erred in exercising its discretion and overturn the relevant findings affected by this approach, identified, for example, in paragraphs 107 and 108 of the appeal brief. Ground 2A.2. The trial chamber erred by applying a heightened standard to rebuttal evidence. The appellant's submissions on this ground are at paragraphs 94 to 114 of the appeal brief and paragraphs 20 to 37 of the reply. Taking judicial notice under Rule 94B creates a rebuttable presumption of accuracy of that fact. However, as the trial chamber acknowledged at paragraph 5272 of the judgment, the ultimate burden of persuasion remains with the prosecution. The appellant submits that the standard applied to the defence rebuttal evidence was heightened. As a result, it was deprived of its opportunity to enliven the debate, and from that, rebut the adjudicated fact. Turning first to the standard articulated in the jurisprudence. Within this, it states that the defence bear the burden to produce credible and reliable evidence sufficient to bring the accuracy of the adjudicated fact into dispute. The threshold of credible and reliable rebuttal evidence, as the Camara rebuttal decision states, is, quote, relatively low. What is required is not the definitive proof of reliability or credibility of the evidence, but the showing of a prima facie reliability and credibility on the basis of sufficient indicia, close quote, paragraph 151. The trial chamber itself recognised in its decision on adjudicated facts that the accuracy of facts could, for example, be challenged through the cross-examination of prosecution witnesses or the presentation of defence evidence to meet this threshold, paragraph 19. Therefore, contrary to the prosecution's assertion at paragraph 37 of the response, the defence was not required necessarily to present rebuttal evidence as part of its case to bring the accuracy of the adjudicated fact into dispute. It was, as the trial chamber acknowledged in that decision, enabled to do so by confronting the prosecution evidence and eliciting inconsistencies and weaknesses therein. Despite this, the trial chamber imposed an erroneous additional requirement on the evidence presented by the defence. It required it to be, quote, unambiguous. Examining the approach the trial chamber took. The trial chamber explained at paragraphs 52-73 how the defence could enliven the evidentiary debate. Quote, in either presenting evidence on a specific alternative scenario as opposed to a mere suggestion of one or more possible alternative scenarios, or in the unambiguous demonstration that a scenario as found in the adjudicated fact must reasonably be excluded as true. Close quote. To further explain what it meant by a, quote, specific alternative scenario, close quote, it gave an example in the only footnote within that paragraph. It reads, quote, if an adjudicated fact stated B killed C, and the trial chamber received evidence that C was possibly / likely killed by A, close quote, it said this would be deemed insufficient to reach the threshold of unambiguous evidence. Footnote 18018. Let's consider that for a moment. If something is possible or likely, then there is doubt. And where there is doubt, as is trite in criminal law, that doubt must be resolved in favour of the accused. To expect the defence to present evidence that is without doubt is to reverse the burden of proof and impose a heightened standard, that of beyond reasonable doubt. It follows then that eliciting doubt through cross-examination of prosecution witnesses, such that inconsistencies or weaknesses could be pointed out, would not be sufficient. Therefore, following the trial chamber's example, to challenge the accuracy of the adjudicated fact on the basis of its standard, the defence would have had to have proved beyond reasonable doubt that C was killed by A, and it would have had to have done so by presenting evidence in this regard. There is no legal basis for this standard. The fact that the trial chamber does not cite a single authority for it in paragraph 5273 is perhaps indicative of this. In the next paragraph, 5274, the trial chamber stated that it is, quote, mindful that evidence contradicting the adjudicated fact does not automatically rebut the adjudicated fact, close quote. The defence also had to show that the evidence that was brought was reliable and credible. The reliable and credibility test was a secondary consideration. As such, the appellant asserts the trial chamber imposed an additional hurdle that the defence had to overcome before it could reach the accepted standard required by the jurisprudence to enliven the evidentiary debate. The appellant submits that in light of the trial chamber's explanation of its methodology, this chamber can be satisfied that it applied a heightened standard. The consequences of this error. The appellant has identified the consequences of this error at paragraphs 106 to 113 of the appeal brief and paragraphs 22 to 37 of the reply. However, here is one example of the trial chamber's erroneous approach. From this, the chamber can see how the test in paragraph 5273 was applied in practice. Unscheduled incident, 24th of October 1994, paragraphs 2001 to 2002 of the judgment. The trial chamber sought to rely on adjudicated facts that said that the shot came from a known sniper location of the SRK and that the shots were fired by members of the SRK. Paragraph 2001, adjudicated facts 2752 and 2753. The defence argued that the prosecution's expert evidence was defected. It also produced a defence expert testimony in which it was said that the trees were likely to have blocked the line of sight. The trial chamber held that likely was not enough to contradict the adjudicated fact. Further, it did not have to address the defence's submissions on the deficiencies within the prosecution evidence because it relied on the unrebutted adjudicated fact, quote, instead, close quote, paragraph 2002. Therefore, even when the defence could introduce doubt through an expert and also point to weaknesses in the prosecution's evidence, this was insufficient to bring the accuracy of the adjudicated fact into dispute. Had the debate been enlivened, the prosecution's evidence would not have been sufficient to re-establish the accuracy of the fact as to the clear line of sight, as it would not have been able to overcome the lingering doubt created by the defence expert and the weaknesses in its own evidence. The appellant submits that the standard applied by the trial chamber to rebuttal evidence was erroneous, and as a result, its approach to the evidence tendered by the defence, or reliance on inconsistencies or weaknesses in the prosecution's case to enliven the evidentiary debate, was flawed. This infected the trial chamber's approach to adjudicative facts throughout the judgment. The examples provided in the appeal brief demonstrate the existence of this systematic error, such that the trial chamber's approach to every single adjudicated fact is called into question. The appellant asserts that this chamber can be satisfied that the trial chamber fell into discernible error and applied a standard that no reasonable trial chamber would, and in fact, ever has. As such, it invites the chamber to reverse the trial chamber's findings to the extent of this error. At this stage, Madam Presiding Judge, Your Honours, I will pass to Mr. Ivitic for submissions on ground 3.
Your Honors, I again incorporate by reference my objection, reservation of rights, and very strong protest as to today's appearance by myself. Again, without the ability to meaningfully prepare with my client and with a reasonable and bona fide question as to his legal capacity to participate, I am limited by my ethical responsibilities to provide you with a very limited, minimal, and shortened summary argument as to the trial chamber's errors as they pertain to a finding of an overarching joint criminal enterprise and my client's criminal culpability for the same. This would be ground 3 of the written appeal. My goal is to highlight the meritorious claim that my client has and to preserve his rights and make a record of the same. In doing so, I do not substitute my participation as being acquiescence nor recognition of today as being the appropriate appellate procedure, nor do I waive anything written in our appeal which I do not have the time to mention. As to the overarching JCE, the judgment is replete with errors, so many that it is rendered unsound, and this chamber needs to take a look at it and correct the same in order to serve both the interests of justice and allow our client, Mr. Ratko Mladic, a fair result in accord with the legal standards. Let's talk about temporal geographic scope. Respectfully, the trial chamber's erroneous approach on the overall assessment of evidence and failure to properly apply acceptable legal standards led to erroneous findings as to an overarching JCE. To start, I would like to draw your attention to the temporal and geographic scope that was found by the trial chamber. That's in paragraph 4232 and in our appeal at paragraph 194. The overarching JCE is defined as lasting from 1991 to 30 November 1995 and is limited to the geographic scope of Bosnia-Herzegovina. it is a fundamental principle of criminal law that there be a temporal coexistence of the actus reus and the mens rea of the prescribed conduct. Adding to the cases we have cited in our appeal brief that support this position, we have the Nahimana appeal judgment at paragraph 313, quote, "The tribunal should have jurisdiction to convict an accused only where all of the elements required to be shown in order to establish his guilt were present." And then later in that same section, the acts or omissions of the accused under any of the modes of responsibility referred to in Articles 6, 1, and 3 of the statute occurred in 1994, and at the time of such acts or omissions, the accused had the requisite intent mens rea in order to be convicted pursuant to the mode of responsibility.
I apologize, Mr. Ivitic. I'm advised that presiding judge's signal has dropped again. Could you kindly bear with us for a minute? Will we reconnect?
Okay. Right. We were disconnected, and I think I'm back. Mr. Lukic, you may continue where you left.
Thank you, Your Honor. This is Mr. Ivitic, and I will continue where the transcript stopped. I would also cite to the Simba appeals judgment, paragraph 266, quote, "The inquiry is whether, at the moment of commission, the perpetrators possessed the necessary intent." Indeed, the Nateletic and Martinovic appeal judgment followed this same approach in paragraph 114. And your esteemed colleague, Judge Tuzmukhmedov, who said to call him Judge T, supported this same approach in his dissent in the Shayinovich appeal judgment at paragraph 8. In the words of Judge T, neither conduct prior to the period of the JCE nor any actions on the part of the accused thereafter could have reasonably amounted to a significant contribution to the JCE. We have correctly argued in our appeal that the trial chamber erred in its approach, especially insofar as to infer mens rea from statements beyond the scope of the overarching JCE made in 1991 in Croatia, not in Bosnia-Herzegovina. Appeal, paragraph 304. First, I note that the indictment alleged that Mr. Mladic was not considered part of the overarching JCE until 12 May 1992, when appointed chief of the main staff of the VRS Army. That's in paragraph 5 of the Fourth Amended Indictment. Prior to that month, he neither was on the territory of Bosnia-Herzegovina nor within the command structure of the VRS Army, since he was in Croatia and the JNA Army at that time. Appeal, our appeal, paragraph 203. Indeed, the first error of the chamber is that it violated the aforementioned jurisprudence by trying to attribute his speeches to Bosnia-Herzegovina in 1991, when Mr. Mladic was neither temporally nor geographically linked to those events. That's in our appeal, paragraph 203. Mr. Mladic was not in the chain of command for receiving reports about events, and certainly could not send commands to persons outside of his chain of command, either to commit these crimes or punish perpetrators. The second error in this respect was that the trial judgment performs an analysis of what others, such as politicians, the police, or other armed groups.
Mr. Ivitic,
yes.
I'm sorry to barge in, but we have lost one of the judges as well, so could you kindly wait till we restart her connection?
Of course.
I think I need to talk. It's muted. Good afternoon, judges. Good afternoon, everybody in the courtroom. IT Judge, one of our judges is disconnected. Judge Kam is back. Anyway, one Judge Ngum is disconnected, and IT advises that we take the 1 hour break now. To resume, To resume 1:25 Hague time. Is that agreeable? Or we are restored?
The defense is fine with that, Your Honor.
Registry? I mean IT. Are all the judges connected?
Madam Presiding Judge, IT colleagues are looking into the issue, and we will revert as soon as possible once the connection has been re-established.
Can everybody hear me?
Madam Presiding Judge, we can hear you.
We now take our 1 hour break. All rise.
All right, we will be.
Now I will move on to the mens rea and actus reus being scrambled and muddled together in the analysis. The trial chamber erred in almost exclusively basing its analysis of Mr. Mladic's purported contribution to the overarching JCE on circumstantial evidence. In using this modus, these conclusions had to be the only reasonable inferences available. I would point to the appeal judgments in Lukic, paragraph 149, and Boszkowski-Tarkulovsky, paragraph 99, for this holding. As we see from the appeal, this was not the case, and the trial chamber thus committed discernible error in finding Mr. Mladic guilty. If I can direct your attention to paragraph 311 of our appeal, we have summarized that there was direct evidence that Mr. Mladic did not share a criminal intent in accord with the overarching JCE, which was not accepted by the trial chamber because it felt it had more circumstantial evidence to the contrary. This disregard of direct evidence in favor of circumstantial evidence is discernible error. It violates the above jurisprudence and violates in dubio pro reo. If the chamber has conceded that direct evidence exists showing a lack of criminal intent or mens rea as to Mr. Mladic, and if indeed that direct evidence is corroborated by other circumstantial evidence, as is shown in appeal paragraph 3112, footnote 463, then no reasonable trier of fact can choose to ignore that direct evidence and go with, quote unquote, more circumstantial evidence to say that the, quote unquote, only available inference is one indicative of guilt. Circumstantial evidence cannot outweigh direct evidence. Much of the direct evidence that was available to the trial chamber and which was disregarded included the notebooks that the chamber asserted as being authored by Mr. Mladic himself. Appeal paragraphs 202, 234, and 309 give some examples. The appellant submits that the trial chamber erred in law by employing a defective method that resulted in a finding of the appellant's mens rea being satisfied beyond reasonable doubt. Based on this fundamental legal error in the method of the trial chamber's analysis, the appellant invites the appeals chamber to overturn the trial chamber's convictions on the JC1 mode of liability pursuant to the Vasiljevich appeals judgment, paragraph 12, and Blashkic appeals judgment, paragraph 13. The first error was that the trial chamber made findings of the appellant's mens rea before the actus reus was established. This is akin to building a house before setting the foundation upon which it will stand. As explained in the appeal brief at paragraphs 271 to 285, to establish the actus reus element of JCE, the trial chamber must determine the existence and scope of a common criminal purpose shared by a plurality of persons. This is a necessary prerequisite in determining whether the acts performed by the appellant were related, contributed to the participation of the common criminal objective. Thus said the Stanisic and Samatovic appeals judgment in paragraph 82. We recall that the doctrine of JCE demands that the appellant made a significant contribution to the crimes for which he has been convicted. Here, both the Krajisnik appeals judgment, paragraph 215, and Burgenin appeal judgment, paragraph 987, set that forth, as does our appeal in footnote 273. This requires the trier of fact to characterize Mr. Mladic's contribution to the common criminal purpose. This is from paragraph 430 of the Burgenin appeal judgment. Here, we must point out that the trial chamber and the prosecution in its response brief make assumptions and draw inferences that of Mr. Mladic to circumstantially link him to crimes based on his position in the VRS and the evidence of behavior of alleged subordinates to satisfy the guilt of Mr. Mladic by this mode. See judgment paragraph 3561, 4218 to 4239. Indeed, the prosecution has misled you by submitting that the word link, quote unquote, between Mr. Mladic in the overarching JCE with other participants is merely any link. Look to their response brief, paragraph 101. Thereby, the prosecution have confused the actual requirement from the Burgenin appeal judgment, which requires an understanding or agreement to be that link, and that's paragraph 419. No other link works. The trial chamber also relied on circumstantial links.
Mr. Ivitic, I'm advised that we have lost the connection with the presiding judge. Could you kindly pause until we re-establish connection? Thank you.
Of course.
Madam Presiding Judge, I'm advised that we have reconnected. Could you reconfirm that, please?
Thank you very much. The session is resumed. Mr. Lukic, please proceed.
As I was saying, the trial chamber also relied on circumstantial, quote-unquote, links rather than finding actual understanding or agreement by Mr. Mladic to support any overarching JCE. Quoting again to Judge Tuzmuhamedov's Sajinovich dissent at paragraph 34, no one incurs criminal liability merely by virtue of being a person of authority or capable of issuing instructions. Responsibility justifying a criminal conviction may attach only to individuals who actually put their powers into use for the commission of crimes or fail to exert their influence over perpetrators. And this must be proven beyond reasonable doubt. Once the actus reus is established, the trial chamber is then required to examine whether the appellant's shared intent to further the common criminal objective could be inferred from his knowledge, acts, words, and interactions with others. Stanisic and Samatovic appeals judgment. Paragraph 82. Again, much like a person building the foundational layer upon which their house will be built, the trial chamber is required to determine the objective actus reus elements of JCE first, before the subjective mens rea element can be considered. And that's from the same appeals judgment, Stanisic, Samatovic, paragraph 82. The appellant submits...
Mr. Ivitic, I apologize. We have lost connection with one of the judges, so we'll try to re-establish connection. Thank you. Madam Presiding Judge, can you see and hear us clearly now? And so, Judge Ngama as well?
I can. Shall we proceed?
Thank you, Your Honor. The appellant submits that the second error in the trial chamber's analysis was when it made mens rea findings while doing the actus reus consideration. That's in the appeal at paragraphs 262 to 290. The consequence of this is that if mens rea inferences are drawn prior to the actus reus being established, not only does this contravene the established method explained in the first error, but how can the trial chamber then, moving into the mens rea consideration, remain objective when they have already made findings about and against the appellant's mental state? Reliance on conclusions already drawn about the appellant's guilt does not provide an objective or balanced analysis of the appellant's mens rea. Instead, the trial chamber automatically applies these findings to conclude Mr. Mladic's guilt, thereby indelibly tainting their findings. You could see this in our appeal, paragraph 291, and our reply, paragraph 55. On this very point, the prosecution was unable to address this error, but rather chose to paint over the elements with a broad brush. The appellant avers that the method used by the trial chamber to establish the different elements of the OJCE are flawed. This invalidates the trial chamber's findings for the OJCE. Such a piecemeal approach deprived the appellant of his rights under in dubio pro reo, fair trial, and the jurisprudence which we have discussed earlier. In essence, the trial chamber has not been able to articulate by what measure Mr. Mladic was involved in crimes or furthered the common criminal purpose. In light of these facts, we submit that the judgment failed to properly characterize through which specific conduct Mr. Mladic contributed to the overarching JCE, again, during the relevant time period he was in Bosnia-Herzegovina and in the VRS. By using such a nebulous and blurred analysis, muddling the actus reus analysis and the mens rea analysis, the trial chamber ultimately left open whether it held Mr. Mladic responsible for active conduct, omission, or both. Now I'd like to talk about the civilian police, MOOP, and paramilitaries. The trial chamber identified approximately 60 paramilitary groups on the territory of the Bosnian Serb Republic, totaling between 4,000 and 5,000 men as of July 1992. And it conceded Mr. Mladic's efforts to disarm and disband those units and groups. See in the judgment, paragraph 3855. No reasonable trier of fact would ignore constant attempts of Mr. Mladic and his VRS to eradicate paramilitaries, while including acts that were alleged to be committed by these same paramilitaries who were named as participants in the overarching JCE. To be blunt, Mr. Mladic cannot have been fighting to eradicate Serbian paramilitaries while at the same time contributing to their actions and thus significantly contributing to the alleged common objective through these paramilitaries. In doing so, the trial chamber failed to give sufficient weight to General Mladic's many orders to subordinates to break up, disarm, and liquidate Serbian paramilitary groups, and arresting them if they had committed crimes. The appellant's approach to not tolerate any actions or existence of paramilitary groups is supported by various meetings evidenced in the notebooks attributed to him. See, for example, in our appeal, footnote 452. Indeed, the consistent opposition of General Mladic to the existence and activities of paramilitary groups is evidenced and documented from the entire period from when he came to Bosnia in 1992 through the end of the alleged overarching JCE in 1995. Please look to appeal, paragraph 310. The selective, erroneous, and biased approach of the trial chamber was followed by a superficial approach on evidentiary assessment as to findings on paramilitary structures. Instead of reaching conclusions in favor of the appellant under the direct evidence of his opposition to paramilitaries, the trial chamber attempted to somehow portray non-existing connections and the impression of joint furtherance of common objectives with the VRS through ambiguous terminology based on circumstantial evidence and unacceptable for proper Article 7.3 analysis. Using words like operated in cooperation, cited several times in the judgment. Look at 3859 and 3866, for instance. Worked in coordination, judgment 3863, pardon me. Worked in cooperation with VRS units, judgment paragraph 3873. But again, direct evidence shows otherwise. One example, an elite VRS unit directly subordinated under General Mladic, the 65th Protection Regiment, was personally sent by General Mladic to Ilija and engaged to deal with a paramilitary group. Here we have Radojcic transcript page 23055, and wherein he continued, that group outnumbered the military police available to that brigade commander, who asked for Mr. Mladic's help to deal with this group. Orders were issued to disarm and arrest them. An example is P5112. Only those who had not committed crimes were allowed to submit to the rules of war and submit to army induction, and they were separated, assigned to different units so as not to work together. Unrefuted evidence defies to meet the requisite legal elements as to JC1 liability. The VRS and Mr. Mladic's position as to paramilitaries is, quote, that the patriotic motives of the above-mentioned individuals are secondary, and unlawful enrichment and looting is the only reason for their presence in this area, end quote. Moving on now to the civilian police known as the MUP, the trial chamber's flawed approach is most evident in its use of adjudicated facts and flawed logic to establish that Mr. Mladic had command and control over the MUP, even though, at most, all he did was order the VRS Army to cooperate in legitimate actions with the MUP. Look at appeal paragraph 218 to 221 and contrast with the trial judgment paragraph 3794. This error is best illustrated in the judgment, where the trial chamber concedes it cannot identify between actions and crimes committed by the VRS or members of the MUP and others, but rather stirs them all together in the same cauldron for purposes of the overarching JCE. And I'll quote that paragraph to you. Quote, many of the charged crimes were committed by members of the VRS who were under the operational command of one of the corps and ultimately of the VRS main staff. Many other crimes were committed by the MUP members, either under the operational supervision of the VRS or under the supervision of the MUP. Some crimes were committed by the territorial defense members under the supervision of the Bosnian Serb Ministry of Defense. Crimes were also committed by paramilitary groups subordinated to the VRS or MUP, end quote. The trial chamber resorted to inventing a brand new mode of liability in command and control jurisprudence, quote unquote, operational supervision. What is it? Upon what basis in law and jurisprudence does it arise? The trial chamber is silent on this point. Evidence to the contrary is not silent and should have led the trial chamber to abandon its creative folly. First of all, evidence was submitted to rebut the adjudicated fact as to command and control. Look at our appeal, paragraph 218. Secondly, the record is replete with reliable and credible evidence that coordinated action of the MUP with the VRS did not lead to resubordination under the Army's command. Here, look at appeal paragraph 221, which includes the prosecution's own expert, Renown Tonins, at transcript page 20615 to 20617. The evidence showed that at all times, the effective control, reporting, and discipline of MUP units remained with the MUP commander and MUP ministry. Appeal, paragraph 221, footnote 327. Based on this evidence as to the MUP, and in accord with the requirements of indubio pro reo, it was unreasonable and therefore an error for the trial chamber to find the appellant shared the intent of the MUP or that he contributed towards the common criminal purpose of any overarching JCE via the actions of the MUP. Now I'd like to switch gears to talk about legitimate goals of the Army. Respectfully, the trial chamber further erred in its conclusions linking Mr. Mladic's legitimate activities to political goals of politicians. The trial chamber found that Mr. Mladic could influence the political leadership. That's discussed in the judgment at 4474, appeal paragraph 204. But at the same time, it refers to evidence that Mr. Mladic was continually subject to the political leadership. Judgment paragraphs 4466 and 4472 through 4474. Indeed, the trial chamber chose selectively the statements of UN outsiders in interpreting the behavior of Mr. Mladic that were often contradictory to one another. We've set that out in the appeal at paragraph 204. For example, contrary to reliance on witness Wilson in the judgment, paragraph 4473, and its use and oversimplification elsewhere in the judgment as to the existence of a supreme command for all tasks and objectives of the armed struggle, it should be noted that the same document used throughout the judgment, P338, at page 159, plainly set forth that General Mladic's VRS main staff was formulating its own military tasks, i.e. 7 overall military goals, instead of 6 strategic objectives as formulated by politicians. There was no malicious meaning attached to them. They simply provided for formulating legitimate military tasks. It should be recalled that this was all at a time when it was clear that the Bosnian Muslims and Bosnian Croats had already established their own armed forces, and attacks by these forces had been directed against municipalities in Bosnia and Herzegovina. The judgment, besides speculative narratives, does not contain conclusions nor important analysis as to whether even the political strategic objectives nor the AB variant document were criminal per se. Hence, conclusions previously reached in the Perisic appeals judgment should direct us, namely that, quote, the implementation of the RS strategic objectives did not entail the systematic commission of crimes, end quote. That's to be found in paragraphs 100 to 102 of the Perisic appeals judgment and must be taken into consideration. It's also identified in paragraph 243 of our appeal. Merely citing and speculating on objectives of a political nature do not satisfy the standard of evidence sufficient to establish the existence of a common criminal plan. We recall here the holding from the Maldic Appeals Chamber that political intentions are not sufficient to establish a joint criminal enterprise, and that's at paragraphs 123 to 124. The absence of any correlation or identical agenda between Mr. Mladic and the VRS on the one side and political authorities on the other, let alone a common criminal objective, is seen in paragraph 3707 of the judgment. But instead of analyzing the clear divergency between political and military goals, the judgment lacks proper analysis and application of in dubio pro reo. Per the arguments in paragraph 206 of the appeal, considering the undue weight given to evidence of the appellant's role in establishing the VRS, in light of the existing jurisprudence that, quote, one's routine duties will not exculpate them, end quote, we submit this standard is interpreted and turned upside down. Performing routine duties in isolation is insufficient to establish indication of guilt and cannot substitute the requisite actus reus or mens rea as to any overarching JCE. The trial chamber failed to explain how performance of routine military duties of Mr. Mladic had an actual effect on and substantially contributed to the activities of perpetrators in the course of crimes in furtherance of the common objective. Without such analysis, the trial chamber has not been able to articulate by what measure Mr. Mladic was involved in crimes committed in furtherance of the alleged common objective. There is a clear error in reasoning that Mr. Mladic has made a significant contribution to the OJCE. It should be recalled in this regard that the VRS in the Perisic appeals judgment was confirmed to be an organization that was not criminal in itself and which undertook lawful combat activities. That's in paragraphs, that's in our appeal paragraph 206. Even a highly controversial doctrine of JCE demands that the appellant made a significant contribution to crimes, which requires the accused's contribution to the common objective. Virgin Appeal Judgment, paragraph 430. How acts and conduct of Mr. Mladic performing his routine duties as a military commander had any tangible effect on crimes which were committed in furtherance of a common objective remain completely unanswered. We reiterate that this is an error, as in paragraph 235 of our appeal. The trial chamber ignored the reasonable inference of Mr. Mladic's comments and speech at the 16th Bosnian Serb Assembly when he first assumed the title, his title in the VRS, wherein he stated, quote, "We do not want a war against the Muslims as a people or against the Croats as a people," end quote. Appeal, paragraph 325. This is said after Karadzic proclaimed the 6 strategic objectives, and its plain interpretation is to only engage in war when attacked and against combatants, not civilians, which is a legitimate stance. Appeal, paragraph 326. By failing to consider the same, the trial chamber erred as to in dubio pro reo. Orders from the VR's main staff in evidence, particularly those from Mr. Mladic, were entirely lawful and legitimate. They were specific to the extent that can be interpreted as of a military nature. Their purpose cannot in any way be connected to any criminal plan or objective whatsoever. Starting with directive number 1, upon assuming command of the VRS, General Mladic consistently urged adherence to the Geneva Conventions and proper treatment of civilians and POWs. Appeal, paragraph 311 to 312. These orders indicate that the appellant ordered his subordinates to abide by international law and did not order them to further the objectives of any common criminal objective. We believe that given the trial chamber's complete disregard of this direct evidence of lawful orders from Mr. Mladic, it is incumbent upon this appeals chamber to intervene in the trial chamber's mens rea analysis, where this direct evidence of probative value has not been given sufficient weight. For those reasons, we would ask that you vacate the trial chamber convictions based on an overarching JCE and grant ground 3 of the appeal, and I yield the floor to my colleague as to ground 4.
Madam Presiding Judge, Your Honours, I will now be addressing the Chamber on ground 4. I will not be addressing the Chamber on every sub-ground within ground 4, which relates to the trial chamber's errors in relation to Sarajevo. My submissions will be focused on ground 4A1, that the trial chamber erred in law by finding that the tribunal has jurisdiction over the crime of terror. The appellant submits the trial chamber's error invalidates the conviction entered on count 9 for the crime of terror. The appellant's written arguments are at paragraphs 336 to 349 of the appeal brief and paragraphs 67 to 69 of the reply. Before turning to my submissions, it's important to note that our argument is focused on the fact that the criminalisation of terror could not be considered to have formed part of customary international law during the indictment period. The appellant does not challenge the finding that there existed a custom on the prohibition against terror. Paragraph 341 of the appeal brief. I will start by considering the legal basis relied on by the trial chamber to conclude it did, in fact, have jurisdiction over the crime of terror. At paragraph 3185 of the judgment, the trial chamber held that, quote, "The appeals chamber has confirmed that the tribunal has jurisdiction over this crime," close quote, and cited 2 cases in support of this conclusion. the Garlic appeals judgment and the Dragomir Milosevic appeals judgment. These will be taken in turn. The Garlic Appeals Chamber, in the first instance, acknowledged the Secretary-General's remarks that, quote, the International Tribunal was expected to apply rules of international humanitarian law which are, beyond any doubt, part of customary international law, end quote, paragraph 81. It then went on to explain the importance of forensically analysing the jurisprudence to avoid confusing a custom prohibiting certain conduct with a custom that criminalises it. This was because, quote, in most cases, treaty provisions will only provide for the prohibition of certain conduct, not for its criminalisation, or the treaty provision itself will not sufficiently define the elements of the prohibition they criminalise, end quote, paragraph 83. After considering domestic practice to determine whether or not there was sufficient state practice to evidence a norm of customary international law for the criminalisation of terror, the Appeals Chamber found that individual criminal responsibility could be inferred from state practice. Paragraph 92. Judge Schomburg dissented. It pointed to 6 states to evidence state practice: the Ivory Coast, Czechoslovakia, Ethiopia, the Netherlands, Norway, and Switzerland. The other states it pointed to, Ireland, Bangladesh, the United States, China, and the former Yugoslavia, on closer inspection, did not, in fact, criminalise terror, so cannot be said to constitute evidence of state practice in this regard. I would refer the Chamber to Judge Schomburg's dissent at paragraphs 9 to 13, and also the appellant's reply at paragraph 68. Therefore, on the basis of 6, or at best 12, states, the Garlic Appeals Chamber concluded, beyond any doubt, a breach of the prohibition against terror in a manner corresponding to the additional protocols in the Geneva Convention gave rise to individual criminal responsibility under customary international law. Paragraph 96. The Appeals Chamber in Milosevic did not take this issue much further. It relied on the Garlic Appeals judgment to conclude that the tribunal had jurisdiction over the crime of terror because its criminalisation was part of customary international law. Paragraph 30. Judge Liu dissented in Milosevic. He alone chose to undertake an independent analysis of the jurisprudence. He endorsed Judge Schomburg's dissenting analysis in Garlic and concluded a custom criminalising terror could not be established due to the absence of sufficient state practice. It's important to consider the Garlic Appeals Chamber's approach to state practice in light of the North Sea Continental Shelf case. In this case, the International Court of Justice found that state practice could only evidence a custom where it was, quote, both extensive and virtually uniform, end quote, paragraph 74. Where state practice is inconclusive, a custom cannot be established. Of the 6 states the Garlich Appeals Chamber pointed to that did actually criminalise terror. There is not a single state from the Permanent Five of the Security Council at the time, not a single one located in Asia, the Americas or Oceania. There are no common law or other legal systems represented. The state practice it purported to find from these 6 states is insufficient evidence of settled practice, extensive practice, or virtually uniform practice as required by the North Sea Continental Shelf case. It falls demonstrably short of what was required to show beyond any doubt that the criminalisation of terror was part of customary international law at the material time. The 4th TADEX jurisdiction condition reads, quote, "The violation of the rule must entail, under customary or conventional law, the individual criminal responsibility of the person breaching the rule." Close quote, paragraph 94. The appellant submits that the Garlich Appeals Chamber failed to establish such a custom. As a result, there are cogent reasons to depart from this decision. I will now consider the impact the trial chamber's deference to this decision had on Mr. Mladic. As demonstrated by paragraph 3185 of the judgment, the trial chamber relied on and recycled the erroneous legal basis proffered by the Garlich Appeals Chamber for the criminalisation of terror. It did so without conducting any form of legal due diligence itself. The error in Garlich was pointed out by the defence at trial, but the trial chamber failed to engage with the issue and concluded that there was, quote, "nothing which would lead it to deviate from the established case law," close quote, paragraph 3185. Had the trial chamber conducted any form of legal analysis, it could not have satisfied itself beyond any doubt that the criminalisation of terror was part of customary international law during Mr. Mladic's indictment period. The Secretary-General made it clear that the principle of nullum crimen sine lege required the tribunal to apply rules that were beyond any doubt part of customary law at the time of the relevant offence. The criminalisation of terror does not meet this threshold. For this reason, the appellant submits that the trial chamber fell into error when it relied on the Garlich Appeals Chamber's findings that it could exercise jurisdiction over the crime of terror under Article 3 of the statute. For this reason, the appellant invites the chamber to overturn Mr. Mladic's conviction on count 9 and remove considerations of the crime from the analysis of the alleged Sarajevo JCE. I will now defer.
May I interrupt you, Ms. Bagat?
Yes, of course.
I think this will be an appropriate time to take an hour's break. Therefore, the proceedings are paused until 1 hour from now. All right.
All right, we will. All right, we will obey.
Good afternoon. We resume now hearing Mr. Mladic's appeal. Counsel for Mr. Mladic, you have the floor.
Please be seated.
If I may begin, Your Honors, I will now address and highlight portions of Ground 5 of our appeal as they relate to the alleged forceful transfer and genocide convictions in counts 2 through 8. I wish to start with the conviction for forcible transfer, which was reached in error and by a disregard of evidence on the part of the trial chamber. Let me try to simplify it for you. As to forcible transfer, the trial chamber selectively relied upon evidence, including Dutch Battalion Officer Franken, only when it supported its erroneous conclusion, but disregarded Franken and his evidence that the forcible transfer was a humanitarian evacuation ordered, indeed organized, at the highest levels of the United Nations, and that the United Nations asked Mr. Mladic to assist with this humanitarian evacuation. This is in Appeal Paragraph 576, Judgment Paragraph 2474 to 2478, 2480 to 2559. In these paragraphs alone, Franken is selectively cited out of context no fewer than 61 times. A close second is insider witness Momir Nikolic, referred to 35 times in these same paragraphs, who, by the way, is identified by the Dutch BAT and other witnesses as the main instigator of abuses relating to the buses, not Mr. Mladic. The trial chamber also relied on other, even lower level Dutch battalion officers who may not have known of the evacuation agreement that the United Nations presented to Mr. Mladic at his first meeting with Colonel Karamans. To try to buttress Franken and support the judgment, the prosecution, in its response at paragraph 224, recalls that the trial chamber also relied upon the evidence of Elko Kuster, an even lower level subordinate who had a direct encounter with General Mladic. Relying on Mr. Kuster's testimony, but not on the video of their encounter, and that's at judgment page, paragraph 5188. Allow me to show you how grave this error is. The entire exchange is video recorded, and as we have stated, look to our reply at paragraph 88, Mr. Kuster has memorized events according to an incorrect contemporaneous interpretation he received on the ground that was not corrected until many years later by the translation services of the ICTY after review of this video that we're now going to look at. So if everyone's ready, I would like to play the video. Waiting confirmation. Okay, here's the video.
Move away from here.
Radi se po mom naređenju, vaški komandant najmanje zanima, trcat ćemo svi koji žele.
He says that all of the people that will get in process, all these things they're doing by his orders, is not instituted.
Žele, bit će prevezeni. Bilo da je malo, veliko.
Anyone who wishes to be transported will be transported, be the person small, big, old, or young. Don't be afraid. Slowly, slowly let the women and the children go first. 30 buses will arrive and will transport you towards Kladanj. From here, you will pass on to the territory controlled by Alia's forces. Just don't panic. Let the children and the women go first. Be careful not to lose a child. Don't be afraid. Nobody will harm you. May you live long.
So, now your honors have seen yourselves that the Serbian words uttered by Mr. Mladic were fatefully mistranslated into something much worse to Mr. Kuster, who, by the way, identified himself as the Dutch bat soldier in the blue helmet speaking to Mladic via interpreter at transcript page 1229 to 1230 when shown this video. And by the way, his commander on the radio is Franken. And indeed, to demonstrate the veracity of Mr. Mladic's intent to engage in a humanitarian and voluntary evacuation, we see Mr. Mladic repeat to civilians that if they want to go, buses will be made available. Mr. Mladic is thanked and praised by the crowd of Bosnian Muslim civilians. Later on in the same video, he talks to another gathering of civilians, and that is in evidence too, explicitly telling them that those that want to stay and return to their homes may do so. So Mr. Mladic's words and deeds in Potocari, spoken in the same language as understood by the Bosnian Muslims, does not accord to the Dutch lower-level officers' understanding of the same. Now, let's take a step further backward. From this appearance in Potocari, what has transpired prior to this appearance? Specifically, this is the evidence that the trial chamber disregarded. That predates Mr. Mladic and the arrival of buses at Potocari. First, the highest leadership of the UN has determined evacuation is necessary for humanitarian reasons from Potocari. Appeal paragraph 578, citing General Cornelius Nicolai, citing Colonel Boring, the deputy commander of the Dutch battalion, and citing Mr. Kingery, the Kenyan UN officer in a blue helmet that we also saw in this same video. Second, Deputy Chief of UNFOR, BH Command, Dutch General Cornelius Nicolai, has obtained the agreement of the Dutch Minister of Defense to issue an order to Colonel Keremans, the Dutch battalion commander in Srebrenica, to obtain Mr. Mladic's help, to ask for it, for an urgent humanitarian evacuation from Potocari. Appeal, look at our appeal footnote 661. Again, this is before any of the meetings at the Hotel Fontana with Mr. Mladic. Third, At the first Fontana meeting, the video shows that Colonel Karaman's expresses that the Bosnian Muslim civilian leadership has asked to leave and conveys the United Nations request for assistance in a humanitarian evacuation to Mr. Mladic. That's the video we just looked at, P1147, and it's an appeal paragraph 578, footnote 663. This is confirmed by the prosecution military expert Butler. It's also confirmed by Karaman's own deputy commander, Boring, who was physically present and testified at trial that the UN did not have enough buses to do this evacuation on its own. You can find that in the appeal in footnotes 663 to 664. Indeed, Muslim civilian leaders had already ordered their own people to leave. Women and children and elderly to Potocari, and fighters to Shushnadi. That's in evidence as P1547, and RM253 testified to it at transcript page 12516 to 12517. These high-level UN meetings and discussions end up involving UNPROFOR Commander General Rupert Smith, Ambassador Yasushi Akashi, and Under-Secretary General of the UN Kofi Annan. Look at D1479. The United Nations asked for Mr. Mladic to help evacuate civilians out of Potocari. The Chamber, finding him guilty of forcible transfer for the same act, would implicate the United Nations and is an unreasonable reading that selectively disregards the evidence. If you watch all three Hotel Fontana meetings in the video P1147, you will see Mr. Mladic welcoming, offering comforts to attendees, including cigarettes, beer, and sandwiches for lunch. This pattern of behavior is similarly demonstrated in the third Fontana meeting, with Bosnian Muslim civilian attendees, including Mr. Mladic offering his own vehicle to safely escort a female participant, Chamila Omanovic, her daughter, grandchild, and mother, during the evacuation. Again, prosecution expert Richard Butler could not identify anything criminal said in these meetings by Mr. Mladic. Ironically, and demonstrative of its error, the trial chamber actually disregarded its own finding, which accepted that during the Fontana meetings, Mr. Mladic offered civilians a choice to leave for Yugoslavia or the Federation, or to stay in Republika Srpska. That is in judgment paragraph 2472 and is dealt with in appeal paragraph 579. Now, let's return to Dutch Battalion Officer Franken, who is among the primary lower level officers selectively relied upon to convert this humanitarian evacuation into the crime of forcible transfer. The trial chamber focused on Franken to say, quote, that the transportation of Bosnian Muslims out of Potocari to Kladanj was not a decision made by the Muslim delegation, but rather ordered by Mladic. Paragraph 5004 of the judgment. It is puzzling and discernible error that the judgment disregarded this witness's own testimony to the contrary in violation of in dubio pro reo. Indeed, Franken acknowledged that his commander, Colonel Karamans, ordered Franken to assist the VRS with the humanitarian evacuation, and that he later found General Smith, that's Rupert Smith, and other high-ranking UN had asked Mr. Mladic for the evacuation, and that separation of men was proper according to the laws of war to see if they were combatants. He testified to this in T 10804 to 10807, 10817 to 10823, 10816, 10824 to 10825, and in his statement D280. Now, most importantly, the trial chamber disregarded that Franken had not viewed error in convicting Mr. Mladic of forcible transfer. Turning now to genocide, extermination, murders, and various other charges relating to the alleged executions of an undetermined number of men in Srebrenica. Let me at the outset make clear, as we have throughout the trial, that we do not dispute that in addition to legitimate combat casualties, some individuals including individuals from the local area, the MOOP, and even Momir Nikolic, and other rogue members of the VRS security professional line of command, took it upon themselves to conduct acts of revenge and killings of prisoners of war, but did so during the time period when Mr. Mladic was not in the area, and contrary to any orders of Mr. Mladic or his knowledge at that time. I must stress that the VRS security line had its own parallel chain of command, separate and apart from the normal chain of command, such that it could exclude Mr. Mladic. Now, it must be stressed that the Krivaya 95 military operation was conceded to be a legitimate military operation due to the failure to demilitarize the Srebrenica quote-unquote safe area. Prosecution can't fight that. Their own lead counsel for this part of the case, Peter McCloskey, said that at transcript page 486. Their chief expert as to Srebrenica, Richard Butler, said that at transcript page 16498 to 16499. It must also be stressed that Directive 7.1 issued by including the Geneva Conventions. Directive 7.1 is P1470, Krivaya 95 is D302. It must also be stressed that the column of men and boys set out from Srebrenica in combat formation and armed and engaged in ambushes, combat, suicides, infighting, minefields, and deaths in quote-unquote kamikaze-style attacks, end quote. Look to appeal paragraph 674. Such that, unfortunately, we will never know the true number of actual legitimate casualties and those related to acts of the crime of murder. We must also, at the outset, repeat that the infamous Fontana Hotel meetings and the language used by Mr. Mladic has been declared legitimate military language, non-criminal, by Richard Butler at transcript page 16831. Thus, the Chamber's conclusion that Krivaya 95 intended the cleansing of Muslims from Srebrenica is an impermissible inference, unsupported by the evidence. We have already discussed this error as to forcible transfer. In order to establish JCE liability of Mr. Mladic for the genocide and killings in Srebrenica, the evidentiary bar was supposed to be set at a high level. Per the jurisprudence, the standard of proof is beyond reasonable doubt, which, quote, presents a high hurdle for the prosecution to overcome, end quote. That's the Miltinovich Trial Judgment, Volume 1, paragraph 62. As outlined by the Martich Appeals Chamber, it must meet more than a, quote, high degree of probability, end quote. That's paragraph 57. And of course, as set forth in the Celebici appeals judgment, it must be the only available conclusion under law and fact as existence of any alternative conclusion mandates acquittal. And that's at paragraph 458. Additionally, since we are talking about genocide, the evidence must, in accord with stated high standards, establish specific intent dolus specialis for genocide. And since it is a JCE, Mr. Mladic must be shown to have agreed to a common criminal purpose and significantly contributed to the same. Now, instances wherein the trial chamber erred in respect to applying the jurisprudence to the facts are too numerous to go through. Allow me to simplify to the most essential. Per the prosecution and per the judgment, the JCE to kill and commit genocide did not even exist prior to the night between 11 and 12 July 1995. This is in the prosecution final trial brief at 1063. It's in the judgment at paragraph 4926, and it's discussed in our appeal at paragraph 586. Now, this is critical. As we've discussed before, under the jurisprudence, conduct and statements before the JCE and outside its temporal scope cannot be used to prove Mr. Mladic was part of that JCE. However, as to Srebrenica, the trial chamber does precisely erroneously rely on that type of evidence. And so does the prosecution. Look at the prosecution response, paragraph 270 to 278, and the trial judgment at paragraph 2358 to 2362. And they also rely on circumstantial evidence and hearsay to attribute Mr. Mladic's agreement to a criminal plan requiring specific intent to commit genocide in addition to murder. For the convictions, impermissible inferences, and indeed, I will call them implied conclusions or implications, you'll see why in a second, are relied upon with no direct support as to Mr. Mladic, who, by the way, fiction. A legal fiction that looks real from afar, but when you get closer, it becomes a mirage. This is a violation of the jurisprudence and discernible error. Now, I do not ask you to take my word for the approach of the trial chamber in this regard. Rather, I would invite you to listen along with me to an insider, the team leader and senior legal officer of the Mladic trial chamber, Jonas Nielsen, speaking publicly at the Asser Institute after the Mladic judgment. Let us see what secret evidence the trial chamber used in its approach to convict Mr. Mladic of the most serious crime of genocide. We have another video. I await instruction.
Good evening to you all. My name is Chris Paars, and I would like to welcome you to the Asser Institute and to this new supranational criminal law, or SCL lecture.
Where in the record this video can be found?
It's in the public record.
It's in the public record in this case?
No, it's in the public record, public domain, and it's germane to the way that the trial chamber dealt with the judgment. It's talking about the judgment.
Can I just have a moment, please, Your Honors? Okay, Your Honors, the prosecution is going to reserve our position on this video. We have no knowledge of what's in it.
Okay. I will rewind it so that we get the whole video. Thank you.
The interpreters note that we do not have a transcript for this video to be able to interpret it into BCS. And without a transcript, I'm not sure that we can continue.
Script in English that was provided, in English, 2 pages. There were only 2 videos, and this was the second one. Does that assist? It should be labeled at the top.
We do have video 1. I'm not sure we have video 2.
It's labeled Asser Institute Jonas Nielsen video. I have a copy if it can be provided. That might assist. I don't have my headphone in.
Yes, thank you. That would assist.
And I apologize if I missed something because I didn't have my headset in. So I'll wait for the document to be given to the booth, and then I'll put the video on. So please give an indication when you are ready. Okay, I have been told that they have it. I will now try again.
Good evening to you all. My name is Chris Paars, and I would like to welcome you to the Asser Institute and to this new supranational criminal law, or SCL lecture. The SCL lecture series is a series on international criminal law and has been organized since 2003 by the Asser Institute in cooperation with the Coalition for the ICC and the HAGUE Center for International Legal Studies of Leiden University. On the 22nd of November 2017, the International Criminal Tribunal for the former Yugoslavia, or ICTY, rendered judgment in its final trial in the case of prosecutor versus Ratko Mladic. After more than 5 years of trial, the rendering of the judgment marked the end, not only of the proceedings in this case, but also of the work of the ICTY. As one of the biggest war crimes trials in history, it presents numerous challenges and lessons that are relevant for other present and future international courts and tribunals. And because of this, I'm very happy that we have an excellent speaker for you tonight, who is in the unique position to give an insider's view of these challenges and lessons. Jonas Nielsen, he has worked at the ICTY between 2005 and 2017 as a senior legal officer and legal officer. and during the last years he was the team leader in Trial Chamber 1, assigned to the Mladic case.
The first question was who ordered the killings of in Srebrenica. There is an interesting passages in the judgment about when, more or less. Now I can't remember the dates in my head, but there is during a certain night when men and boys are being captured, detained, and held, and there was discussions between the military leadership and Mladic is around, and there's no meeting, there's no order, written order. There's no meeting where we have minutes where it says where this is set out. But the trial chamber looked at various indication what was said on a certain day and what was said in the evening, what was discussed with various people, and then suddenly what was discussed the day after, and what, in particular, what some witnesses, some insiders testified, what they were indicating, and it was possible to somehow pinpoint more or less. Not by the hour, but which night this decision must have been taken. When it was, when the decision was taken that from deporting or capturing or whatever these men, the decision was taken that they should be killed. Now, I don't know exactly who did it, but there is certainly an implication that this is the whole military leadership was, the high military leadership of Bosnian Serb Republic was involved at the time, and Mladic was present around this time as well in Srebrenica, so certainly the implication that he must have been involved in taking the decision. I don't think there is a finding on this particular, and there didn't really have to be a finding on it in the context of the joint criminal enterprise. Had it only been charged with ordering, then it would be not necessary to go that far, and maybe it's not possible to go that far, because again, there's no written order, there's no meeting minutes or anything like that. It's somehow what you can understand from the change of attitude by people, high military leaders who were involved, and someone who then stepped forward and testified in the case.
So the reason I show this is to show that the trial chamber...
The council is just asked to pause a little bit until the interpretation into BCS is finished. Thank you very much.
So the reason I showed this is because it demonstrates that the trial chamber created a legal fiction, including participation in a meeting that they don't know who was there, if it took place at all. They don't know where, but they convict Mr. Mladic merely by implication for genocide, the highest crime of all. There's an admission of no orders. In fact, no particular finding as to Mr. Mladic's participation, nor acceptance of this illusory meeting's conclusion to commit genocide. Nothing. Mr. Nielsen stuttering on possibilities and implications based on nothingness. No application of in dubio pro reo or any of the relevant jurisprudence. And to reach a conviction as to Mr. Mladic, they have to interpret changed behaviors in persons other than Mr. Mladic and key insider witnesses who testified. I submit the conviction of Mr. Mladic for genocide was made out of thin air. But let's look at who the key insider witness relied upon by the chamber for this infamous meeting that, again, they cannot prove. Mr. Nielsen doesn't say. Per the judgment, this insider is Momir Nikolic. Appeal, footnote 678. Judgment, paragraphs 4926 to 4927, 4970, 5096 to 5097, 5128. Even worse, it is not Momir Nikolic himself, but primarily hearsay evidence, including hearsay notes of an interview taken by OTP investigator Bruce Bursick for purposes of litigation that is among the main sources cited, and that's D1228. Please take note that D1228 was not presented for the truth of the matters asserted in it, and was only presented to Mr. Nikolic by the prosecution to confirm a hand gesture from a purported meeting with Mr. Mladic. The trial chamber rejected that as being unreliable evidence. That's in the judgment, paragraph 5127. In fact, D1228 was only used in cross-examination of witness Bursick to establish that Nikolic lacked credibility and was evasive, and that the prosecution violated its own rules by not filming the critical interviews where he alleged to implicate Mr. Mladic. More importantly, Mr. Bursick could not corroborate Nikolic as to any encounter with Mr. Mladic. That is in our appeal, paragraph 588 to 592. D1228 could not be relied upon as the truth of the hearsay comments of Mr. Nikolic, as it would be in violation of the lex specialis of then rules 92 bis and tour. We have the jurisprudence listed in footnote 691 of our appeal. Now, Momir Nikolic is someone who appears everywhere that there are killings, either directing them or as an accomplice. He admitted to hiding the burial operation from superiors, including the VRS main staff. That's in D301, page 7, and during his testimony at T11965 to T11966. The trial chamber further erred in relying upon Mr. Nikolic despite another prosecution insider witness, RM265, who testified as to opportunistic revenge killings that they witnessed in the presence of Momir Nikolic, and that prisoners of war taken to schools in Zvornik were undertaken under the orders of Momir Nikolic and Nikolic's superior within the security chain of command in the brigade, Lieutenant Colonel Popovich. That is at P2450 and P2451. RM265 did not implicate Mladic in any of Nikolic or Popovich's illegal and criminal activities. It is all the more interesting that Momir Nikolić's security chain of command superior is implicated, that is to say Popović, by another prosecution insider witness from the VRS, a high-ranking officer, RM376, who also does not implicate Mr. Mladic in any of the events relating to revenge or killings, but does identify that the very same Popović of the security chain of command asked for volunteers outside the army, i.e. civilians, to execute Muslim prisoners, which this VRS officer refused. That's at P1594, page 31 to 42, and in the public transcript 2794 to 2796. Now, this all begs the question. If General Ratko Mladic, commander of the main staff of the VRS Army, had hypothetically, or to use Mr. Nielsen's term, implicitly agreed to significantly contribute to genocide, why would security officers aligned with Momir Nikolić, not even in the direct chain of command to Mladic, be in charge of this? And why would they be asking for non-army volunteers to do the killing, while actual VRS officers and subordinates under Mladic refused such requests and never received them from Mr. Mladic through the normal chain of command? I think you will agree this demonstrates an error in the trial chamber's implied reasoning linking Mr. Mladic to these crimes. Momir Nikolić pled guilty to try to get a better deal for himself, despite having his arms soaked in blood. Further, Nikolić confirmed he destroyed documentary evidence which could have compromised him in relation to Srebrenica crimes. That's D301, page 7. But guess what? Coming back to this illusory meeting, even Momir Nikolić cannot be relied upon by the chamber as to this illusory meeting, because even he does not have direct evidence about it. See the judgment at paragraph 4953. See the appeal at paragraph 587. So, to what imaginary insider VRS witness testimony linking Mr. Mladic to this supposed meeting is Mr. Nielsen referring to, upon which the trial chamber relied? The defense submits no one. No fewer than 5 insider witnesses, 3 defense, 2 prosecution, gave direct evidence that the only meeting during this critical time period was related to JEPA and contained only legitimate military instructions. Look to appeal paragraph 594. By disregarding this evidence in favor of impermissible hearsay of Momir Nikolić, the trial chamber erred. This is particularly true given the jurisprudence that accomplice evidence is to be treated with caution. The Satako Appeals Chamber highlighted such concerns that accomplice witnesses may have motives or incentives to implicate the accused person before the tribunal or to lie. Satako Appeal Judgment, paragraph 143. This Satako Appeals Judgment requires a chamber to be bound to carefully consider the totality of the circumstances in which such accessory evidence is given. With all due respect, in the instant case, as to Momir Nikolic, the trial chamber erred, and in doing so, tried to make Nikolic the illusory link to Mr. Mladic with the JCE that could not be proven in accord with the prevailing legal jurisprudence, and thus resorted to the legal fiction of guilt by implication. Now, we've already talked about Fontana. I'm not going to, and Potocari and all the words of Mr. Mladic there. I'm going to talk about the other evidence, again, by several prosecution and defense witnesses, that Mr. Mladic made similarly non-criminal statements to captured or surrendered members of the 28th international community. In Belgrade in a wedding and at a hospital, he could not have effective control nor information from Bosnia and Herzegovina, let alone exercise command. Again, his absence was not contested by the prosecution at trial. Appeal paragraph 605. The failure of the trial chamber to give a reasoned opinion as to 4 routine orders issued in this time by others under Mr. Mladic's name is set forth in paragraph 610 to 612 of our appeal, including errors as to an inference that Mr. Mladic personally signed said orders from another country, and failure to analyze and give weight to their content because none of them related to Srebrenica, and each had log entries showing they did not come from Mladic's office. Appeal paragraph 611. The trial chamber's conclusion that Mr. Mladic issued the orders and was in command and control while he was physically and geographically absent from Srebrenica in another country is contrary to evidence and is therefore demonstrable error. It disregarded and contradicted itself in the judgment in paragraph 4299 that, quote, in Mladic's absence, reports were to be submitted to Milovanovic, end quote. Now, Milovanovic and other military witnesses confirmed that during this time period when Mladic was gone in July of 1995, Milovanovic was in charge. Stevanovic at transcript page 35265, and Milovanovic himself at transcript page 11751 and 16950. Furthermore, in paragraph 605 of the appeal, strike that, I'm going to move on. In paragraph 605 of the appeal, we talk about the meeting that Mr. Mladic attended, where a plan was signed to allow the Red Cross access to Srebrenica POWs, and that they were to be exchanged, quote, all for all, end quote, with the other side for Serb detainees. Also, a lasting and permanent ceasefire was negotiated to try to end the war. No reasonable trier of fact could conclude Mr. Mladic could engage in complex peace negotiations with high officials in Dobanovci, again, UN officials, while exercising effective control in Srebrenica. Such conduct, agreeing to allow access to the Red Cross of Srebrenica POWs before exchanging them, cannot be used to support knowledge of nor a purported contribution to any JCE to exterminate, let alone commit genocide against these same persons. Moving along, I'm almost done. My colleague has given you the law on adjudicated facts. We recognize that any illegal killings in Srebrenica that were outside of combat are reprehensible, but they are not tied to Mr. Mladic. And the trial chamber erred in not performing any analysis to determine which were victims of murder and which were deaths resulting from alternate legitimate reasons. The trial chamber relied upon adjudicated facts to establish all were victims of crimes and all were civilians. Judgment paragraph 3062, 3546, discussed in our appeal at paragraph 669 to 672. In doing so, the trial chamber disregarded its own finding that the armed elements of the column of men had casualties. This is discussed in appeal paragraph 671, judgment paragraphs 2395, 2444, 2446, 2573 to 2586, 2515 to 2645. The trial chamber further disregarded the prosecution's own demography expert, whose evidence indicated that 70% of the Srebrenica column, and since trial, they have died and become deceased. thus increasing the gravity of this refusal and this error. When everything is taken together, we believe the errors are very clear and ground 8 must be granted and an acquittal issued as to Mr. Mladic. Your Honors, at this stage, that is about all that either myself or my colleague, Ms. Bagot, can do. We, under these circumstances, would refer you to our written submissions, as we have no further oral submissions, given our inability to meaningfully seek instruction from our client. And I thank you.
Thank you, Mr. Lukic. And I think this will be a suitable time to pause for an hour. All rise.
All rise. We will be.
Thank you. No, Shiva. I think we're 1 hour behind.
All right, we will obey.
Good afternoon, everybody, or is it good evening? You can hear me, everybody? Please sit, you may sit down.
Please be seated.
Please be seated. The appeals chamber will now hear the prosecution's response. For the prosecution, you have 1 hour for this part of the session.
Apologies, Madam Presiding Judge. Mr. Mladic has stood to his feet, and I believe he has something he'd like to say at this point.
Your Honor, this is the 9th hour. I've been here for 9 hours now. As far as tomorrow is concerned, I would like to ask you for us to follow the prior procedure. We could have a short break, not 1 hour. I spend 4 hours in a room, an isolation room. I can't put up with this sort of thing. I won't be able to put up with it tomorrow. I'm sorry about this.
As I understand, the 1 hour break we have is to facilitate fumigation of the courtroom. And I would therefore invite the registry to respond to that, whether it's possible to make the breaks shorter.
Madam Presiding Judge, I will take that on board and alert my colleagues to it and revert to the chamber before the end of the session. Thank you.
Thank you. Now, counsel for the prosecution, you may proceed.
Thank you, Madam Presiding Judge. Your Honors, Ratko Mladic is not a war hero. He is a war criminal. He abused his vast military power to deliberately target the civilian population, destroying lives, families, and communities. Mladic was properly convicted and sentenced after a fair trial for some of the most heinous crimes of the 20th century. And during the trial, which lasted more than 3.5 years, the chamber received evidence from nearly 600 witnesses and admitted almost 10,000 exhibits. And after comprehensively assessing the totality of this extensive evidentiary record, and with full respect for the burden of proof and the criminal standard of beyond reasonable doubt, the chamber found Mladic guilty of war crimes and crimes against humanity, as well as genocide in Srebrenica. His crimes affected hundreds of thousands of people, with long-term effects that are still felt today. And for the extreme gravity and scale of his crimes, Mladic was properly sentenced to life imprisonment. In his appeal, Mladic calls into question vast portions of the trial judgment, seeking full exoneration, a retrial, or a reduction in his sentence. But none of Mladic's grounds of appeal show any error warranting Your Honor's appellate intervention. On appeal, it is not enough for Mladic to say that he wanted a different outcome. Instead, he bears the burden of showing errors in the trial judgment that meet the well-established standards of review on appeal. He cannot do so. He does not even come close. For example, many of Mladic's arguments seek to trigger review of the entire trial judgment based on what he calls illustrative examples, impermissibly asking Your Honors to figure out if his arguments could apply to other unspecified findings or other unspecified incidents. Throughout his appeal, he misstates the record, the trial judgment, and the jurisprudence. He improperly reiterates failed trial arguments without engaging in the trial chamber's reasons for rejecting them, and he repeatedly claims that the trial chamber disregarded evidence that the trial chamber clearly considered in the trial judgment. These flawed arguments show no error. They cannot even come close, and many warrant summary dismissal. Mladic's appeal should be dismissed in its totality. I'll begin the prosecution's response today by addressing Mladic's arguments concerning the overarching joint criminal enterprise. That's ground 3. And then my colleague, Ms. Goy, will make submissions on ground 4, Sarajevo. And tomorrow, I will address Srebrenica, ground 5, and Ms. Goy will conclude by responding to Mladic's remaining grounds of appeal. Starting with ground 3, concerning the so-called overarching joint criminal enterprise, the purpose of which was to permanently remove non-Serbs from Serb-claimed municipalities in Bosnia and Herzegovina through persecution, extermination, murder, deportation, and forcible transfer. The trial chamber reasonably concluded that at the latest, when Mladic became the commander of the VRS main staff on the 12th of May, 1992, he joined with other Bosnian Serb leaders in pursuit of this common goal of ridding entire municipalities of non-Serbs. That objective was to be achieved, quote, by whatever means, paragraph 4222. Your Honors, in the face of the extensive evidence proving his responsibility, Mladic's appeal is manifestly deficient. He focuses primarily on the chamber's weighing of individual pieces of evidence. He argues that the chamber could have looked at this evidence in a different way to reach an acquittal. But nowhere does he explain how his proposed approach to these individual items of evidence, taken in isolation, would have impacted the chamber's conclusions. And nowhere does he address the chamber's analysis of this same evidence and these same arguments at trial. And nowhere does he show that the trial chamber's findings were unreasonable. This does not reach the appellate standard. Appeals chambers have repeatedly emphasized the margin of deference afforded to the findings of fact by a trial chamber. Mladic might not like these findings, but nowhere in his appeal does he give Your Honors a reason to change them. I'd like to begin by highlighting some of the chamber's conclusions that led it to find that this joint criminal enterprise existed, and addressing the challenges to this conclusion, before turning to Mladic's significant contribution and finally to his mens rea. Your Honors, there is no doubt that an overarching joint criminal enterprise existed, which Mladic joined in 1992. Mladic knew, even before he joined, that violent takeovers, which transformed previously multi-ethnic municipalities into Serb-only municipalities, had already begun. In 1991, preparations began to establish separate Serb political institutions at the republic and municipal levels. And pursuant to the instructions of the Bosnian Serb president, Radovan Karadzic, Bosnian Serb authorities created Serbian crisis staffs and mobilized Serbian police and territorial defense units in each of the municipalities. The Bosnian Serb leadership agreed with Mladic's proposition that their plan had to be guarded as their deepest secret. Your Honors, in reaching this conclusion, the Chamber carefully considered the statements of all of the participants in this meeting and the context of the meeting. My learned colleague cannot show error in the trial judgment by highlighting a single excerpt out of context. For the Chamber's finding, I would refer you, Honors, to the trial judgment at paragraph 4222. As the Bosnian Serbs took power in more and more of the municipalities, Mladic's VRS soldiers worked together with other Serb forces under the control of other JCE members to commit crimes. These forces included the police units of the Bosnian Serb Military of the Interior, referred to in the judgment as the MUP, and the territorial defense units of the Ministry of Defense, called the TO, and the Serb paramilitary units under the command of the VRS or the MUP, and members of regional and municipal authorities. Members of the JCE, including Mladic, used the forces under their control as tools to commit crimes in the municipalities, as found by the trial chamber at paragraph 4239. And let me pause here, Your Honors, to clear up two legal issues that were raised this morning. First, with regard to tools. The law does not require an agreement between the tools and the JCE members. My learned friend accused the prosecution of misleading the court by suggesting that any link was sufficient. This is not the prosecution's position. The Brjanin appeals judgment explains that JCE members can use tools to carry out the actus reus of the crimes. The link between the tools and the JCE member who's using them is a factual matter to be assessed on a case-by-case basis. And I would refer Your Honors to paragraphs 410 to 413 of the Brjanin appeals judgment. subsequent jurisprudence has clarified some of the situations that satisfy this test so that the crimes of the tools can be attributed to the JCE members. For example, when the tool belongs to a hierarchical organization, such as the military or police, that is controlled by a JCE member. And I would refer you, for example, to the Mladic appeals judgment at paragraph 187 to 188. The Brajanin appeals judgment, paragraph 419, was cited this morning for the proposition that there needs to be an agreement between the tools and the JCE member. But this paragraph plainly says the opposite. It says that the trial chamber in that case was in error when it required such an agreement between the JCE members and the tools. The second legal issue that I'd like to address concerns the relevance of evidence outside the temporal scope of the joint criminal enterprise. And here, Your Honors, we need to distinguish on the one hand between, on the one hand, the timing of the contribution, which must coincide with the mens rea, and must generally be within the temporal scope of the joint criminal enterprise as charged. And we distinguish that with, on the other hand, the evidence used to prove that actus reus and mens rea, which is not restricted in the same way. The trial chamber was entitled to rely on evidence concerning events before and after the joint criminal enterprise to establish both the actus reus and the mens rea. And the case law shows that the trial chamber's approach was the correct one. And I would refer Your Honors to the appeals chamber's 18 April 2002 decision in the Slobodan Milosevic case, and to the Perlich appeals judgment, paragraph 711. The trial chamber correctly and reasonably found that together, the JCE members and the tools working under them unleashed unimaginable violence, creating an environment so coercive that tens of thousands of non-Serbs were left with no choice but to leave the territory. Bosnian Muslims and Croats were fired from jobs, subjected to other discriminatory measures. In Prijedor, those who weren't expelled or sent to the camps were required to wear white armbands to distinguish themselves from the Serb population. On the radio, propaganda spread and encouraged ethnic hatred and discrimination. Mladic's soldiers, working with other Serb forces, attacked predominantly non-Serb towns and neighborhoods. They indiscriminately shelled civilian areas. In a single attack in Prijedor, over 800 inhabitants were murdered. Serb forces were cold-blooded and methodical, reading names off lists, executing women, old men, children, forcing victims to jump from bridges and then shooting them to be sure that they were dead. According to a witness, the river was full of corpses. Muslims and Croats were rounded up, families were separated. Non-Serbs were stripped of their valuables, forced to hand over their property. Convoys of buses and trains were organized by the Bosnian Serb authorities to drive tens of thousands of men, women, and children out of Bosnian Serb claimed territory. Human beings, torn from their homes and communities, fearing for their lives, forced onto buses and convoys guarded by armed soldiers, suffocating in airless refrigerator trucks crammed onto freight trains. The Bosnian Serb forces intended that they would never return, They burnt Muslim and Croat places of worship and destroyed non-Serb homes and businesses. Serb property was spared. The trial chamber found that across the Serb-claimed municipalities, non-Serb civilians, male and female, young and old, were also detained en masse. In-transit and detention camps established throughout the municipalities, often with the support of the VRS. Detention camps whose names are synonymous with human suffering: Batkovic, Manjača, Omarska, Karaterm, and Ternopile, Kapidom, Foča, and other smaller makeshift prisons in factories, schools, sports facilities, police stations, and other public buildings. And over the course of 1992, non-Serb civilians were arrested and detained throughout this camp system in appalling conditions. Overcrowded, unsanitary, lacking food, water, and medical care. Many were raped and sexually assaulted. Women and men, girls as young as 12 and 13. Many were beaten and tortured. Many were forced to do dangerous labor and used as human shields. Many died from starvation and abuse, and many were executed. Their bodies dumped into mass graves, buried and reburied to hide their murders. In one of the most notorious camp massacres, VRS soldiers gassed and then slaughtered 200 detainees with a single machine gun while the guards sang songs. And I'd refer you to paragraph 1121 of the trial judgment. While this event stands out for its horrific facts, it is by no means unique. Prisoners in these camps face death every day. And for the vast majority of the detainees, their only crime was their ethnicity. And this is what the realization of the common criminal purpose looked like. This is what it had to look like to achieve their goal, which was a complete redrawing of the regional map. Mass suffering in the name of ethnicity. The JCE's campaign was as brutal as it was successful. By the end of 1992, most of the territory claimed by Mladic and the other JCE members had been rendered ethnically pure Serb territory. In 5 of these municipalities, the crimes committed were so extreme that the trial chamber found that the local perpetrators, most under Mladic's direct control, intended to destroy those parts of the Bosnian Muslim group. Paragraph 3526. And Mladic and the other JCE members continued this violent ethnic cleansing campaign until 1995 in order to cleanse a few remaining Muslim enclaves in eastern Bosnia. This, Your Honors, is the basis for the trial chamber's conclusion that there was a joint criminal enterprise. This intense pattern of violence committed by soldiers and others under Mladic's command, working hand in hand with police, territorial defense, paramilitaries, and administrative authorities. And it's against this background that Mladic claims that there wasn't a JCE, that he wasn't a member, because he purportedly acted to protect non-Serbs. For example, because a limited number of non-Serbs remained in one municipality, or because of a couple of entries in his notebook about purported constraints that his army experienced, or because of supposed good deeds he ordered, which, as we've explained in our response brief at paragraphs 54 to 60, were neither relevant half years across the 14 municipalities convincingly proves the opposite. Your Honors, there was an overarching joint criminal enterprise in the municipalities, and the concerted actions of Mladic's military, along with the other Bosnian Serb organs, proves it. Mladic shows no error in the Chamber's conclusion. This brings me, Your Honors, to his challenges concerning the Chamber's findings on his JCE contribution. The trial chamber found that Mladic's contributions to the overarching joint criminal enterprise were not just significant. They were instrumental. It concluded that without his contributions, the crimes would not have been committed as they were. And in reaching this conclusion, the trial chamber considered Mladic's many contributions to this goal. The summary and conclusion can be found at paragraphs 4611 and 4612 of the judgment. First and foremost, Mladic was in command and control of the VRS, members of which were found to have been involved in a vast array of crimes from 1992 to 1995. Mladic's contributions, analyzed extensively in Chapter 9.3 of the trial judgment, go far beyond the routine duties of a legitimate commander. Mladic raises three main arguments against the trial chamber's findings on his JCE contribution, all of which claim that the trial chamber failed to give sufficient weight to his preferred evidence. Again, without demonstrating error, without engaging in the chamber's treatment of that evidence, and without showing that no reasonable trier of fact could have made that finding. Before I address the three arguments, I want to focus for a moment on what he does not challenge. Because Mladic only challenges a few of the JCE contributions found by the chamber. But even if these challenged contributions were removed, his remaining contributions would still have been sufficiently significant to meet the legal requirements for a JCE contribution. Especially when you consider, as the trial chamber did at paragraph 4612, that many of the crimes were perpetrated by the VRS. He does not challenge, for example, the chamber's conclusion that he contributed to the JCE by establishing and maintaining the VRS, including by seeking assistance from Serbia in meeting the ongoing needs for personnel, equipment, and ammunition. He does not challenge the finding that he contributed by addressing the Bosnian Serb Assembly and advising the political leadership. He does not challenge the chamber's finding that he contributed by introducing and maintaining a propaganda machinery aimed at spreading anti-Muslim and anti-Croat fear and hatred. And he does not challenge that he contributed through deliberately misleading the international community about the crimes, or the chamber's conclusion that he contributed by severely restricting humanitarian aid in the later part of the JCE. These findings that Mladic does not challenge would still amount to a significant contribution. Turning to the challenges he does make. His first argument concerns the resubordination of the MUP police forces to the VRS. Mladic claims that he lacked general command and control over the police, and so crimes committed by the police could not form part of his significant contribution. Now, the Chamber did make general findings that the police were in some instances resubordinated to, and in other instances cooperating with, the VRS. But the Chamber's specific findings on Mladic's own contribution to the JCE were much more narrowly focused and conservative. The only contribution based directly on crimes committed by the police concerned the police in Menjača camp, one detention camp in Banja Luka municipality, and I would refer your honors to this specific finding in paragraph 4404 of the judgment. Similarly, Mladic's contribution through failure to prevent and punish crimes was expressly limited to crimes of the VRS and the other Serb forces discussed in chapter 9.3.4. And with regard to the police, this was again limited to Menjača camp. That's at paragraph 4544. In other places, the crimes committed by the police are attributed to Mladic through the other JCE members, but they are not counted as Mladic's personal contribution to the joint criminal enterprise. So Mladic's arguments about general command and control over the police is irrelevant to the question of Mladic's personal contribution. Likewise, Your Honor, the crimes of the paramilitaries were only specifically counted as Mladic's contribution in those couple of situations where the paramilitary group was specifically found to be under Mladic's command and control. And I would refer you to paragraphs 4402 to 4403, and again 4544. Turning to his second argument, Mladic claims that the trial chamber failed to give sufficient weight to evidence that his lack of professional subordinates affected his ability to command the VRS. Even assuming this were true, he never explains how inexperience would deprive him of effective command and control. But many of the VRS soldiers under his command were not inexperienced. The trial chamber detailed how the VRS was formed, drawing on the ranks of the 90,000 experienced soldiers of the JNA, the Yugoslavian People's Army, who were Bosnian Serbs. The trial chamber found at paragraph 3747 that many of the commands and units of the JNA simply renamed themselves units of the VRS. So the VRS did not start off with just Mladic and a few officers, as we heard this morning. For example, the JNA 5th Corps simply became the VRS 1st Krajina Corps and was established between the 12th and 20th of May, 1992. That's trial judgment, paragraph 147. It was the largest VRS corps with a zone of responsibility including half of the municipalities in the Bosnian Serb Republic. Of course, the trial chamber considered evidence of actual indiscipline. This was already factored into the trial chamber's consideration of the strong evidence of Mladic's very high level of command and control over his subordinates. This included evidence from Mladic's own subordinates, including defense witnesses, proving that Mladic was in command, was respected as a leader, and that his orders were strictly adhered to. Mladic's third argument is that the trial chamber failed to give sufficient weight to evidence that he did not know of specific crimes, and therefore his failure to punish the perpetrators should not be counted as JCE contributions. As we point out in our response brief, some of the documents he relies on actually informed Mladic the crimes were being committed by his subordinates. One notes concerns of the ICRC about detention facilities, and the other reports a massacre of detainees. But even if this evidence could be read in his favor, it doesn't get his argument anywhere. The trial chamber did not find that he knew of every incident because it did not need to. The evidence was sufficient for the trial chamber to conclude more generally that Mladic knew that crimes against humanity and war crimes were being committed against Bosnian Muslims and Croats in the municipalities and in the detention facilities. To reach this conclusion, the chamber reasonably considered the extensive evidence concerning Mladic's hands-on command, as well as the fact that the crimes in question were widely acknowledged and reported by the international media and the United Nations. This was sufficient to trigger his superior responsibility to prevent and punish. Yet the chamber found that it did not receive any evidence of any Bosnian Serb being prosecuted for war crimes committed against non-Serbs between the 12th of May 1992 and the 30th of November 1995. That's paragraph 4545. Instead, Mladic chose to cover up the crimes and to promote and congratulate VRS officers involved in atrocities. None of Mladic's three actus reus challenges show any error in the trial chamber's conclusion. Turning finally, Your Honors, to Mladic's shared intent. Mladic challenges the mens rea analysis on the basis of methodology and because it's based on circumstantial evidence. First, there was nothing wrong with the chamber's methodology. The chamber's approach was fully consistent with the logic set out in the Stanisic-Samatovic appeals judgment. And I should clarify here that the Stanisic and Samatovic judgment does not stand for the proposition that trial chambers must, in every instance, follow a particular order of analysis. Its holding is more narrow, that the trial chamber in that case erred in finding that the mens rea element was not met without having first adjudicated the other elements of joint criminal enterprise responsibility. But in the Mladic case, the trial chamber did follow the order of presentation recommended in the Stanisic-Samatovic judgment. It set out the existence and scope of the JCE and whether the accused acts contributed to that purpose before determining whether he shared the intent. And there is no reason to think that the trial chamber's findings are in any way tainted by a purported mix-up between the actus reus and the mens rea findings. This argument rests on the idea that a trial judgment is a linear document that records a sequential deliberation on each topic in a particular order. But as the case law has repeatedly emphasized, trial judgments must be read as a whole. And I would refer you, for example, to the Sayanovich appeals judgment at paragraph 306. But in this case, there was no mix-up, and there is no taint. Mladic cannot identify a single clear example of this problem. What his examples do show is the chamber using language that is consistent with its mens rea analysis in the contributions chapter, and cross-referencing in the contributions chapter to the evidence reviewed in the mens rea chapter. There is simply nothing wrong with this, as Mladic acknowledges at paragraph 288 of his appeals brief. There is nothing improper about a chamber relying on the same underlying evidence or factual findings to draw conclusions on different aspects of the case. Mladic's second argument concerns the chamber's reliance on circumstantial evidence to make intent findings in particular. In Mladic's view, the chamber should have preferred what he calls direct evidence of his mens rea. But this argument is wrong on two levels. First, there is no legal support for his preference for direct evidence, not in relation to mens rea, but also not in relation to the many other instances that he raises, where he raises this distinction throughout the appeal. Criminal intent can be, and absent a confession usually is, proven primarily through circumstantial evidence. And in his reply at paragraph 64, Mladic denies that he's arguing that direct evidence is inherently more valuable than circumstantial evidence. Yet he repeatedly claims that direct evidence is automatically stronger. And my learned colleague submitted this morning that circumstantial evidence cannot outweigh direct evidence. This is incorrect. The tribunal's jurisprudence is clear. There is no rule that a chamber should prefer direct evidence. The only rule is that a chamber has to consider the evidence in its totality, including both the direct and the circumstantial evidence. And this is because the probative value of evidence is determined by looking at it within the totality of the evidence in the case, not by labeling it direct or circumstantial. And this is what the trial chamber did in this case. It looked at the totality of the evidence before concluding at paragraph 4688 that Mladic shared the common purpose and intended the underlying crimes. And the evidence of Mladic's mens rea was overwhelming. It included his expressions of commitment to an ethnically pure Serb republic, his statements indicating that he was willing to disobey the laws of war, his fomenting of fear and hatred towards Muslims and Croats, his repeated use of derogatory terms for Bosnian Muslims and Croats, such as Turks, Balijas, and Ustašas. And of course, his long-standing instrumental contributions to the common purpose with full knowledge of the crimes committed in its pursuit. Paragraphs 4685 and 4686. Your Honors, the jurisprudence is also clear that on appeal, the same standard of review for factual findings, the reasonableness standard, applies whether the evidence is direct or circumstantial. And I would refer you, for example, to the Galich appeals judgment, paragraph 9. Mladic cannot meet his burden by claiming that his preferred evidence is better or should have been given more weight because it was supposedly direct rather than circumstantial. Nor can he succeed on appeal by proposing different inferences than the trial chamber based on isolated parts of the evidence. Instead, Your Honors, to show error, he must address the totality of the evidence and the chamber's analysis of the whole evidentiary record. He did not do that in his written briefs, and he has not done that today. Turning to the second point concerning the direct and probative evidence that Mladic repeatedly claims was disregarded. It was not really any of those things. It wasn't direct, it wasn't probative, and it wasn't disregarded. Much of the evidence that he labels as direct is actually circumstantial evidence of his intent. For example, at paragraph 309 of his appeals brief, he calls the paramilitary orders direct. But what he's actually seeking is an inference that reflects his disapproval of crimes. Technically speaking, this makes the evidence circumstantial for the point that he's trying to make with it. But the evidence he complains about does not have significant probative value in light of the totality of the evidence. For example, evidence that Mladic occasionally ordered adherence to the Geneva Conventions weighs very little when compared with the powerful evidence showing that he knew that his troops were committing war crimes and crimes against humanity with his approval and support. The trial chamber was entitled to conclude that these orders did not demonstrate his true intent. In any event, all of this evidence was analyzed in the trial judgment. None of it was disregarded. When the evidence was found to be relevant, it was addressed by the chamber in its reasoning. Mladic cannot show error by complaining that the trial chamber failed to specifically refer in the mens rea section to irrelevant evidence or to evidence that it found to be unreliable or inaccurate. To conclude on ground 3, Your Honors, the chamber reasonably found on the totality of the evidence in this case that Mladic was a member of the overarching joint criminal enterprise, that his contributions were instrumental, and that he shared the intent to commit the crimes of persecution, extermination, murder, deportation, and forcible transfer. Mladic's deficient arguments show no error. Your Honors, ground 3 should be dismissed. Madam Presiding Judge, we're at your disposal. We can start with the Sarajevo response right now for 10 minutes. We believe that we can get through most of it within the next 10 minutes. Do we have sufficient time, or would you rather pause at this stage?
I think you have 10 minutes. My time here is
but the criminalization of terror, the individual criminal responsibility for the crime of terror, also formed part of customary international law at the time of the events. The infliction of terror upon the civilian population at the time of the Sarajevo events has been adjudicated in a number of cases before the ICTY and the mechanism. In Galic, the ICTY trial chamber examined the criminal responsibility for the crime of terror under customary international law, but ultimately relied on an agreement between the parties to the conflict in which the parties agreed to apply certain rules of international humanitarian law, including the prohibition of terror, and agreed to punish those responsible for violating the rules. That's the Galic trial judgment, paragraphs 124 and 127. The appeals chamber in Galic found the criminalization of terror based on customary international law after a careful analysis. That's the Galic appeal judgment, paragraph 98. This holding was confirmed by the ICTY appeals chamber in the Dragomir Milosevic case, in the last ICTY appeals judgment in Perlic et al., and by the mechanism appeals chamber in the Karadzic case. Mladic fails to provide cogent reasons to depart from this settled jurisprudence. Rather, he complains that there was insufficient state practice, but ignores that the Galic appeals chamber did not only rely on national laws. The Galic appeals chamber also pointed out in paragraph 93 of the appeal judgment that terror as a war crime was first referred to in a report published in 1919 by the Commission on Responsibilities. The Commission on Responsibilities was created by the Peace Conference of Paris to inquire into breaches of the laws and customs of war committed by Germany and its allies during the First World War. Moreover, the statute of the ICTR confirmed the customary international nature of terror, even for non-international armed conflicts. It explicitly contains acts of terrorism. As the ICTY appeals chamber in Chalabici noted, when the Security Council established the ICTR, it was not creating new law, but was codifying existing customary rules. That's the Chalabici appeal judgment, paragraph 170. This shows that the crime of terror formed part of customary international law by the time Mladic committed terror in Sarajevo. And importantly, Mladic himself could foresee that his conduct in Sarajevo could lead to a conviction for the crime of terror. He could foresee this not only based on the international sources I mentioned, but also because terror was criminalized in the 1976 Yugoslav Criminal Code. Mladic is correct that this Yugoslav Criminal Code did not define terror, but it did criminalize subjecting the civilian population to terror, quote, in violation of rules of international law effective at the time of war, end quote. And these rules on international law effective at the time of war were set out at the time of the events in Sarajevo in the 1988 Yugoslav military manual. This military manual explicitly said that attacking civilians for the purpose of terrorizing them is explicitly prohibited. That's on page 29, paragraph 47 of the military manual that your honors will find in the Book of Authorities to the Prosecution Response Brief. So read together, the criminal provision on terror and the 1988 military manual made criminal responsibility for terror sufficiently foreseeable to Mladic, a career officer in the Yugoslav army, the JNA, who had served for almost 27 years before he became the commander of the VRS main staff on 12 May 92. This conclusion is supported by the ICTY Appeals Chamber in Galic. There, the Appeals Chamber held that the same combination of provisions, the Yugoslav Criminal Code and the military manual, was relevant to the foreseeability of incurring criminal responsibility for terror for Mladic's subordinate, General Galic. That's the Galic Appeal Judgment, paragraph 96. Your Honors, the ICTY had jurisdiction over the crime of terror, and ground 4 should be dismissed. Your Honors, might this be an opportune moment to break for the day?
You have 4 minutes, but if you think this is the right time to break, we can
think so.
adjourn.
Because
Very
we would
well.
start a new ground, and that might be better to start tomorrow. Thank you, Your Honor.
Very well. Now the appeals chamber will adjourn to tomorrow and start at 9:30 for the prosecution to continue their reply. All rise.
All right, we will.